Hey everybody, good morning, good afternoon, good evening. How are we all doing? I'm just thrilled. We've got through the Christmas holiday. We are back in the saddle again. We've got the Bryce Rhodes trial done. Now it's time to get back to things, and that's what we're going to be doing here today. We're a bit behind on the Maya Kowalski proceedings, and so that's what we're going to be doing today. We're going to be catching up as much as we can on that. So we've got a new supplementary motion that was filed by the defense. Then we had the hearing on whether or not to have a new trial based on a number of assertions by the defense team, and the court has issued its ruling in one of those. And as probably everybody here knows, the ruling that the court handed down was that they would be interviewing juror number 1. So we're going to be looking at all the stuff that leads up to that, to find out what it is that led up to this decision. Then we'll read the court order, and then we should be pretty much caught up to date. The juror number 1 will be questioned by the judge on January 3rd. And we have a lot to get through here tonight, and we got to keep it as close to 2 hours as we possibly can so I can sleep. So let's jump right into this. First, however, we got to do a little bit of house cleaning as per usual. Right. Okay. Oh, here's YouTube asking me if I want to do it live in-stream ads. No, thanks. Turn that off before it gets started. We've currently got 234 of you here and 108 likes. Thank you so much to the 108 of you that have done that. The other 60% of you haven't done that yet. So pop on down there and make sure you hit that like button. And if you haven't subscribed, I would be extremely honored if you would subscribe to me. Give me a chance with your subscription. It doesn't cost a thing. It's completely risk-free. Just, click that subscribe button and continue to watch, or forget about me. It's your choice. But I would be honored if you would do that. If you would subscribe to the channel, if you haven't already done so. And if you have, please double check to make sure you're still subscribed, because YouTube just likes to unsubscribe people for reasons. And after you have liked, hit that like button. After you have subscribed and made sure you're still subscribed, vote in our daily like and subscribe poll. Today's like and subscribe poll is: how do you feel about juror number 1 being interviewed by the court? So far, 53% of you have said angry, 21% of you have said it's understandable, 19% of you have said make it make sense to me, and 7% of you have said you don't care one way or the other. And as people continue to come in, continue to take the poll, we'll look back at the like and subscribe poll in about an hour, about the halfway mark, and see how things are going then. But all right, until then, hey guys, I hope you all had a wonderful, wonderful holiday. Whether it started at Hanukkah, whether it started at Christmas, December's a holiday month, and we're winding down. We've got New Year's coming up at the beginning of next week. So I hope everybody had a fantastic holiday season up to this point. If not, I hope it gets better. And for those of you that joined me for the chill Christmas stream the other day, that was a whole bunch of fun. We might do one for New Year's. I don't know. I don't know. I haven't decided what we'll do for New Year's Eve yet. Smopo Vienna says nobody beats your viewers like ratio. Watch Good Logic earlier. It was a good show. 1,000 plus viewers, only about 400 likes. Crazy. Well, I'm a likable guy, I guess. Gelfling. All right, Elsie Merritt, whatever brought that on. Okay. Just kind of scrolling. Your poll is hard to take. We need more foreplay. Well, we're going to be starting with with this new motion. Well, the latest motion. It's not really new motion. It's been around because we've been busy with the Bryce Rhodes murder trial, triple murder trial. Now that we're back into this, let's just jump straight into it, shall we? All righty. Let's see. No other business to take care of yet. If any super chats or any of the monthly chats come in, whatever, we'll hit those, and we'll try to bring up as many of your chat streams as we possibly can. So let's present the screen for the motion. Motion. Who's got the motion? There's the motion. We got 2 snoring dogs over here already. So if the dogs, if you hear all the snorting, heavy breathing, and whatnot, you all know it's Strawberry and Yoda over here sleeping. It's not just me. It might be partially me, but it's not. It's not all me. All right, can we even begin this any further? Yes, we can, because I can pop myself down here, and that'll allow us to make it one step bigger. No, that's just far too big. Unless we stretch this out. No. Yeah. All right, that's kind of big, isn't it? Oh well. That's what she said. All right, let's go. Third supplement, because you remember the first supplement was all they first filed this motion that we had to have a new trial because juror number one was doing all of these things when actually they were just making allegations that his wife was doing things. Then the first supplemental was he was involved in something 20 years ago, some sort of criminal thing 20 years ago. Then the second supplement was he called Susan Smith a Nazi. Well, there we go. Well, hi YouTube. I'm just quoting, things. Don't hold the N word against me. It's odd. Anyway. I won't get into the YouTube stuff. Sorry for saying the nosy word, people. But that's what he said. And now we have the third supplement to the defendant's motion for a new trial based on juror misconduct, motion for juror interview, motion to open discovery and evidence of juror misconduct, and emergency motion to preserve evidence. Defendant Johns Hopkins All Children's Hospital, Inc., by and through undersigned counsel and pursuant to rules 1.4 and 1.5, Florida Rules of Civil Procedure, files this third supplement to its motion for a new trial based on juror misconduct, motion for juror interview, motion to open discovery into evidence of juror misconduct, and emergency motion to preserve evidence. Paragraph 1. A copy of juror number one's completed juror questionnaire reflects that juror number one checked the boxes indicating that he had A, previously been charged with a crime, and B, has not been the victim of a crime. Attached as Exhibit A, please find juror number one's juror questionnaire. During the voir dire questioning of juror number one, he professed that he had checked a box by mistake, refuting that he had been charged with a crime. Attached as Exhibit B, please find a transcript of the court's voir dire of juror number one regarding this topic. Subsequent to the entry of the verdict in this case, undersigned has learned that juror number one has indeed been the victim of a serious crime. A box that should have been checked, but was not. Attached is Exhibit C, petition for injunction, final judgment of injunction, and related case documents. This event took place in 2016, the same year as the Kowalski hospitalization issue. Juror number one misinformed the court that he was not previously a victim of a crime. When this was specifically discussed with the court, he had an opportunity and obligation to advise the court and counsel of this past case, and undeniably failed to do so. A potential juror's dishonesty, misrepresentation, and failure to be truthful on a juror questionnaire, and a juror's failure when having further opportunity to correct the misinformation provided to the court is grounds for a new trial. See Taylor v. Magana. Trial court abused discretion in denying new motion for a trial where juror concealed information that was squarely asked for on the questionnaire. Importantly, this third supplement is timely filed in support of defendant's prior timely motions for new trial, see Roberts X Real Estate of Roberts. Trial counsel is not required to conduct an investigation of the veneer during trial in order to satisfy due diligence and determine whether a veneer is like the jury panel, has been involved in prior litigation so as to be able to later challenge juror non-disclosure. And then we have that, and then there's the copy of the juror questionnaire, and then there is about 500 and, there's a little bit of the trial transcript, and then there's like 38 pages of just everything redacted. So that's the end of the motion. The previous motion that was filed just before the hearing. And now, just to refresh your memory, and I'm sure most of you remember this way better than me because my brain works like that. We've got the defense making several arguments as to why they should be given a new trial. One of the main features is what we're talking about here, the alleged misconduct of juror number one. Recall they laid out all these things, were posting online, where his wife was posting online, his wife was sitting next to Jules in court, his wife would talk to the defense once, his wife talked to the plaintiff once, his wife took a picture with the plaintiffs once. Jack Kowalski allegedly looked back and smiled at her at some point. She sat in just all of these allegations as to what juror number one's wife did. And somehow they pulled that back into the big umbrella of, well, they lived together, so surely they must have been talking about the case. And therefore, we should get a new trial. And they've also argued that the judge made a few errors in law and that the jury made errors in calculating damages. And they asked the court to step in if necessary, if all of these other things that they're trying to get a new trial, trying to get a new verdict amount set. And if all that fails, they want the judge to come in and just set his own damage numbers, much lower than what was awarded by the jury. So this leads us up to the trial the hearing that took place about 10 days ago. And we're going to watch a substantial portion of that. I've skimmed through it just to get some timelines and to check a few things. We're going to deal mainly with the allegations against juror number 1 because that's what the order dealt with. The order that was just handed down the other day. So we want to see what was argued by the two counsels. Well, actually, by both sides, there was more than two counsels arguing and making their motions. Hear what the judge said. Because now that we know the outcome, now that we know that juror number 1 has been ordered to attend the court on January 3rd and be questioned by the judge, we can look for the reasons why and see at what point the judge may have telegraphed his intentions that this is what he was going to do. Yeah, and Jules says, Jack never looked at me. I wasn't looking down. Yes, I took pictures. Juror number 1's wife never disclosed who she was. No one knew she was there. I mean, I was looking down. Yeah, that's one thing that we went back and we saw subsequently that he was. I can't remember who he said that he was talking to. Who the plaintiff said he was talking to. I think he was talking to their jury expert, I believe. But yeah, Jules wasn't looking around. So she wasn't having eye contact with juror number 1. And again, we have to default to the let's suppose that it did happen the way the defense argued it. So effing what? Jules said Dr. Scott Richards was who it was. Yeah, so effing what, even if it did happen the way that the defense alleged. But anyway, let's jump into this and see what's going on with this motion. I'll give you my take on it. Most of 95% of what I'm going to be showing now is me seeing it for the first time. I tried to avoid other law tubers, there are other lawyers' commentary on this because I didn't want my own views to be tainted or twinged or influenced by what other lawyers may have to say about this. What I normally do is after a hearing, then I'll do it myself, and then I'll go see what other people said to see if I was right, to see if anybody disagrees with me. All right, let's bring this up and we'll get going here. All righty. Where is the hearing? Share screen. There it is. Right. Detach that. We can minimize that. I'm sorry, I'm readjusting windows on the fly here. Cool. Right. And I will embiggen myself slightly here. That's not the one I want, is it? Nope, that is definitely not the one I want, nor is that. There we go. That's the one. That's the one I was fishing for. I need to get a new lawn crime cage. I need to have a new one made so that we can throw that up over there. But all right, let's get on with this hearing that took place approximately 10 days ago, where the lawyers are going to be arguing their points about juror number 1's alleged misconduct.
Case number 2018 CA 5321 Kowalski versus Johns Hopkins Children's Hospital. Starting with the plaintiff, let's take appearances, please.
Well,
Anderson, Nick Whitney, also we have Tom Elliott. And
first thing I note is that it's only in one ear. It's only in the left channel. Maybe that's just me.
Howard Hunter with Chris Altenberg, Ethan Shapiro.
Let's see.
Pat Crowell for Johns Hopkins.
See if we can do 1.25.
Thank you. And I assume everybody got the agenda that we're going to follow this morning in the second amended order. So why don't we just get right to it? First topic is going to be the issue of alleged juror misconduct, whether we should be having a hearing, and if so, what the contours of that hearing would be. Mr. Shapiro. Yes, sir.
May it please the court, Your Honor, I actually break this down into two separate and distinct arguments, either of which would warrant a new trial and at a minimum warrant the juror interview. The first is the duty of jurors to adequately and honestly disclose during voir dire any material issue that could affect their jury service. In this case, juror number 1 has 3 material omissions or misrepresentations based on his verdict form, and I'll discuss all 3 in turn. The first was he was asked on his juror interview question whether he or an immediate family member had ever been a victim of a crime, and he checked no. We've since discovered that both he and his wife had filed an affidavit and prosecuted their stepson for threats and looks like what was being threatened as a murder of both of them in the form of a sworn affidavit to Detective George Richards on March of 2016. There's very detailed statements about this. I think they're part of the record, but if not, if I may approach and hand Your Honor a copy. This cannot possibly be something that a juror would forget to disclose. This was a question directly asked. And as Your Honor and the court would review the affidavit, there's multiple instances in here where both juror number 1 and his wife state that their safety is at issue, that there were threats made against them that they wish to prosecute. That's certainly something that.
Well, was it prosecuted? Was there a guilty verdict? Was there some sort of finding of guilt? Was there an admission of guilt? Because if not, then it's only an allegation of a crime, isn't it?
Sensitivity of this, but we have to make it as part of the record that in 2002, juror number 1 was served with an injunction for domestic violence, of which there's a sworn affidavit of child abuse. That file is obviously sealed, so I can't see what the allegations are, but they are part of the record. That would be something that they would have a duty to disclose both during the questionnaire and during voir dire.
That's bullshit from over 20 years ago.
Had that been disclosed, that certainly would have led to a cause challenge, if not a peremptory, if the cause challenge was denied. The third,
and if I recall, that wasn't prosecuted either.
This trial?
Yes, Your Honor. The third was in the questionnaire prior to the one given to the witnesses. There was a list of witnesses that may be present, of which there was Deborah Salisbury. Deborah Salisbury, as we've learned and as we filed with the court, it turns out she was juror number 1's wife's attorney for her divorce proceedings, the same attorney who represented Mr. Kowalski. That was never disclosed to us either. The case law on this is very clear. Under Rule 1.431, we're entitled to an interview of the juror if there's a reasonable basis, and I'll get back to that. But I think the controlling case on this that's really undisputed is the De La Rosa case from the Supreme Court of Florida at 659 Southern 2nd 239. There's a 3-part test utilized to determine whether a juror's non-disclosure of information during voir dire warrants a new trial. The first part of the test is that the complaining party must establish that the information is relevant and material to the jury, to the jury service in this case.
Okay.
3 would be material and relevant, but certainly in a case where there's allegations of medical child abuse and a juror has been served with an injunction for child abuse, that's something that we would have to know about. Certainly being a victim of a crime, especially one involving one's family member, would be something we would need to know about, and both of those were withheld from us. The second test.
I haven't gone back to look at all of the juror questionnaires, but were there other juror questionnaires where the juror checked family members been a victim of a crime, and then did your side ask questions of those individuals?
I haven't gone back through all the voir dire, but
well, you're making a statement, a very express statement that you would have used a peremptory challenge.
Right. Okay. That's a notable thing. He's making definitive statements that this would have happened if anybody would have done this, and then he admits that he didn't go back and check to see whether or not whether they had treated everybody the same, whether anybody that checked this box would have got additional questioning by him. So yeah, that's not a good way to start. That's not a good way to make the judge happy. And all right, let's see how the judge handles that, because you're making this blanket statement. Yeah, you haven't looked at everybody underneath that blanket, have you?
And I'm just wondering if it was so important when that question was asked for other people. What did you do?
The law on what I'd have to go back to my voir dire questions and see what would happen, but I know that in each individual, for the questionnaire, all of these were asked by the court, if you recall, and that the court asked those questions. If we had follow-up questions during the individual sessions, we would have asked them if it was material to the case. Certainly, if somebody was saying they were a victim of a crime involving another family member, I absolutely represent to the court, that would be something I would have followed up on. No basis to, and in fact, the case law says.
But you can't say whether or not you did or would have because you didn't read all of the juror questions. All right.
Under both State Farm Mutual v. Lawrence at 65 Southern 3rd 52 and Westgate Palace v. Parr 216 Southern 3rd 747, that the counsel is not required to delve further into questions on the questionnaire if the answer is no. So there's under the three-part.
Yeah, but what about the times when the guys answered yes on them?
Whether a juror's failure to disclose information was not attributable to my lack of diligence, the case on this says that if there's an express no to the checkbox, there's no duty on behalf of counsel to further investigate that question. So we believe we've met all three prongs under the De La Rosa test. And on this specific issue, since all three are material, especially the ones involving child abuse, and especially the more recent one involving a very serious allegation that both he and his immediate family member, being his wife, were victims of a very serious crime by another family member, the failure to disclose that at the front.
What his wife was a victim of has nothing to do with him.
So that's my argument on the non-disclosure. And at this point, Your Honor, I would switch gears to the argument about what we would phrase as improper influence, if not jury tampering, from the outside. And so, we put together a very detailed PowerPoint presentation that we filed as part of our motion for new trial regarding the social media postings of juror number one's wife, and how those.
I hate PowerPoint presentations.
Is a very real belief that information influenced and was known to juror number one during his deliberations and during the trial. This has been noticed as non-evidentiary, I understand, so I'm going to try to move along. I didn't bring the PowerPoint to it since it's been filed with the court.
Yep,
I do want
I can hear that.
the record, the timeline of this, because I think if the court sees the timeline of this, you can see that the alarm bells are really ringing. If we go back, even if you start with what we filed as a record, the juror question that was filed on October 12th with the Sally Smith's name spelled in the SS logo, and we filed that with the court, we're not accusing juror number one of being a Nazi.
Well, let me ask you about
Yeah.
Yeah, you're not accusing juror number one of being a Nazi. You're accusing him of calling her one.
every single juror question. My habit was to read the question at sidebar, and since I'm right-handed, I would use my right hand and turn it over, and almost always I handed it directly to you to look at. And so not only did you hear the question, you had the opportunity to physically look at the sheet. And then about halfway or 2/3 of the way through the trial, your side asked for a copy of all the juror questionnaires. That same day, I had the clerk provide them.
Okay, so he's saying that the defense counsel had the opportunity to actually look at the questions, to look at the questions themselves. In other words, they were right there. You're closest. You get them. You would have seen the symbols, alleged symbols, rather. You would have seen the jagged S's.
To you,
All
so
right.
you had them. So why was this not addressed in your motion that was made? You know, you waited a couple of weeks, but then you made a motion to disqualify the juror, but said nothing about this. So how is it that this issue isn't waived even before we get to the merits of the issue?
We frankly did not appreciate the difference in the lettering, Your Honor. Had we appreciated, we would have raised it.
I don't understand what you mean. You couldn't tell that the S was different than other questions, or you didn't know that this was in your mind what you were so definitively saying is evidence of juror number one calling Sally Smith a Nazi. So, I mean, what is it?
Well, with respect, Your Honor, I don't think anybody, including the court, appreciated the difference in the lettering in the moment. Had we done so.
Well, your second supplement is extremely definitive. And so
Judge is onto him here. Yeah. You had it, you saw it, you could have raised it at the time. So, well, we didn't appreciate it at the time. So I guess now the judge is going to ask him, well, you were very definitive a couple of weeks later. So now, what was it that made you definitively realize that maybe you should have said something back then?
I'm wondering, one, why is this issue not waived? And two, what is the good faith basis for the statement and the assertion you made, or actually Mr. Hunter made in the
go into good faith?
What other plausible explanation would there be for distinct lettering for Sally?
Oh, don't be asking the judge questions. Judges do not like that. The judge is asking you the questions. Do not reply to a judge with asking you a question with another question, asking him to explain. He asked you to explain. That's your job, not his.
Especially in the eve of Mr. Anderson giving interviews to Court TV, accusing the defense of following the Nuremberg defense of we're just following
Jesus.
orders. Had this been only an isolated situation where one juror question has different lettering in the absence of any other suspicion of hostility, we may share this court's view that that would be an extrapolation. But
My recollection is that you all made a big stink about Mr. Anderson's interview that next day.
Yeah.
And we had to talk about it and discuss it. So I don't see how you can say you didn't appreciate the issue when you physically saw the questionnaire and you were later given it during the trial. So why is this issue not waived?
These issues are, from a legal standpoint, a procedural standpoint, the motions for new trial and requesting a juror review are preserved as long as they're brought within 15 days. There's no legal obligation that we can see that all of these issues need to be timely brought during the trial. Now, certainly, Your Honor, had we appreciated it, we would have added it to our
Well, what
motion.
made you appreciate
Given
it?
the breadth of it, I
What
did
made
not
you
appreciate
appreciate
the
it?
breadth.
That's what the judge is
I
asking.
don't think the court did. It wasn't glaringly obvious to us as we're reading questions from the bench and focused on the substance of the question.
Well, how did you come to appreciate the difference?
Somebody pointed it out to me.
You can continue.
On October 19th, we put a lot of the social media postings of juror number one's wife. And look, spouses of jurors are entitled to opinions. That's not the issue.
Yes.
The issue is a lot of what's posting here. And I don't think the plaintiff is going to argue in rebuttal that her postings are not extremely pro-plaintiff. That's not even the issue directly here. The issue is
That's not even indirect.
given the hostility of juror one's questions and timing his questions to what she's posting online gives a very strong presumption that they were communicating. Starting on October 19th, juror number one's wife was posting online about the lineup for the next day that included Detective Stephanie Graham. And then the next day when Detective Graham's on the stand, she's posting in real time on social media that her husband's going to have questions for Detective Graham.
Well, we were all saying that.
Because anyone who was at the trial knows juror number one was basically going to ask questions. Maybe not as certain as death and taxes, but probably as certain as there's going to be a traffic slowdown on I-4 around Disney.
Nice.
So
That's good.
How is that evidence of
Exactly, because that's, again, we're beating a dead horse with this. This is what every single lawyer in I didn't watch any of non-lawyer reactions to this just because I was sticking with the other lawyers reviewing this thing. That's what we were all saying. The guy's a cop. He's going to be asking questions. And especially when there's another detective on the stand, he's going to be asking questions. Everybody said that. Everybody was anticipating his questions.
inside information?
Judge, again, if this is the only instance of juror number one's wife predicting who he's going to ask questions to and when, again, in isolation, if that was the only issue, I would appreciate it. But as we lay out, there's about 15 more instances that combine with it. And even in, again, in real time, I appreciate the court shared the email from the woman from South Africa questioning the integrity of the Kowalskis. We call her the agent, regardless of what she is. She's, you remember Jules in the courtroom. She's been online saying she was texting with Maya, texting with the Kowalskis. She's calling into YouTube blogs and saying what the jurors are thinking. And
so what?
Shared with the court.
So what?
Shared it with us, but as part of the email, when you look at it, she's talking about juror number one shaking his head hostilely towards defense witnesses.
So
that Jules is calling into the talk.
Gee, that's what courtroom observers and trial watchers do, dumbass. And I just judging by the way the judge is asking questions, I don't think he's buying this for a second.
Show saying that that they're hostile to all of the defense witnesses, and you get to what I think is very glaring was the October 26 questions when Sally Smith's video was played. I'm sorry, when Sally Smith took the stand. If you look at what juror number one's wife was posting online at that point,
doesn't matter.
She is, again, I don't need to establish the plaintiff bias, but it's concerning to the defense that when you look at her social media follows, it's not just the pro-plaintiff blogs. It's the Take Care of Maya producer. It's Mr. Anderson's jury consultant. And she writes on October 27th, I think Sally Smith only relied on Tampa General to decide this case. At the same time, her husband's asking the same questions that Your Honor may remember Mr. Anderson was complaining to the court. We need to clarify that the 2015 Bonnie Rice call was different than the 2016. When you look at his questions, they are, quote, why would Dr. Rice, a TGH doctor, need to call you, Sally Smith, about Maya when you're over at ACH? And then he asks the second question, why is Bonnie Rice calling you to raise the red flag? They're sharing the same questions and the same concern and the same confusion. You know, again, when you fast forward.
Well, from a timing perspective, didn't juror one ask the question first and then?
Exactly. That's absolutely correct. And again, we pointed that out as well when we were going through the motion, that the defense tried to portray this as she said, you know, this is a question we have. And then the next day, the juror number one asked the question, or the timing, I believe it was actually like a week or so ahead. He asked that he was asking the question, but it was very, very clear that the juror number one asked the question before juror number one's wife mentioned anything about it. So, I mean, that's ridiculous.
There were comments from, I don't know what to call it, the public.
Did I just skip ahead?
Trying to discern what juror one asked the question first, and then there were comments from, I don't know what to call it, the public. You know, trying to discern what the question meant.
They were made at the same time, yes, sir.
Now, which one was first?
Yeah, they can't possibly be made at the
Those
same time.
questions were first.
So assume that the statement was from somebody other than the wife. If someone sitting in the gallery observes a question and then comments in a public forum about
Right,
the meaning of it or the questioning of it, how does that show inside information
right.
with the juror?
Because it's a discrete issue of sincere confusion that they both share on the same topic. And, you know, again, under the totality of the circumstances, as the defense is looking at this in retrospect, it belies credibility that the two of them share the same confusion on the same topic with absolutely no communication. And, you know,
No, I haven't had any communication with him, and I had the same confusion. No, I think Shapiro clearly knows he's lost this particular issue, and he is grasping frantically at straws. He's thinking on the fly, and he's not thinking on the fly very well, trying to find a way he can possibly turn this ship around. And I don't think it's going to work.
you know, because of the time limitation, I just want to fast forward to the part that I really think is concerning. You know, we filed a video of juror number one's wife sitting next to Jules in the courtroom. Again, this justice system requires not just obviously that the jurors be sequestered from outside information, but it requires the appearance that everybody participating in this tribunal is fair and impartial. I find it impossible to believe that, and I'll say it, that the Kowalskis didn't know at that point, because Jules is texting with him and communicating with him, that she didn't just spend the day with juror number one's wife. And that when we made the motion to disqualify juror number one for our feeling that he was no longer fair, that he was no longer impartial, somebody has a duty to let the defense and the court know, hey, by the way, his wife was in the courtroom. She's
Why do you don't, nobody has a duty to tell you that anybody or anybody's wife is in the courtroom. That's crap. That's just a bunch of crap. And you know, you knew somebody was sitting back there, dude. You saw that she was there. Why didn't you say something about it? Why didn't you raise the issue? This is dumb. I mean, this is sheer desperation. Let's take a little bit of a quick pause here with Mathis agrees. Juror number one disclosed stepson had been charged with a crime. Well, they're arguing he didn't, and again, it was 20 years ago. It was almost 22 years ago. I don't think it matters. Oh no, this was on 2016. Yeah, the argument they're saying that he didn't disclose he was the victim of that crime. But again, I don't know that there was a judgment in that case. If there's not a judgment, there's only an allegation that it was a crime, as far as I'm concerned. It's only a crime if a judge or a jury finds that it occurred. And also, thank you again for 2 more euros. The PPP uses European timestamps. More Reddit work. Well, Reddit's all over this. We made a PowerPoint, so you must have quit, J Hatch, says Unhung Hero. I hate PowerPoint. I just do. It's just say it. Or all right, I won't get on my personal I hate PowerPoint trip, but I do. Thank you so much, Unhung Hero. Unhung Hero again coming into another super chat. Reddit are pretty much known for seeing not seeisms everywhere. Oh yeah, well, anytime you get a community of like-minded people together, you're going to start going down some really odd rabbit holes, conspiracies. It just happens. Whatever side of an issue you're on, you get a group of hardcore believers together, and they're inevitably going to wander pretty far afield from whatever the true course is. It's just a thing. People feed on each other, and then you start to foment this, super like or super dislike of whatever side you're on, and you'll interpret things in favor. Absolutely, and the entire group will interpret anything in favor of them to use it as a confirmation bias. To this happened there, and both sides can look at the same exact incident or the same exact piece of evidence and say, no, it completely supports our side, or no, it completely supports our side. It's groupthink, and it happens when any group gets together. Reddit sort of seems to be where they coagulate. J.A., thank you so much. Jules, the last defense from government tyranny and the tyranny of the corporate oligarchies. Jules can go to court. Just come on. I can't imagine that they really enjoyed making these arguments. I mean, these are so spurious that I can't imagine that he feels good right now making these arguments. I couldn't. That's what I mean. He probably feels great. He probably feels righteous indignation on behalf of the aggrieved hospital. But I can't put my mind in that position. So I just don't know how. Chris Rowland, PowerPoint violates Geneva Convention for torture, especially when, okay, PowerPoint is good for summarizing what you're saying. Talk for 5 or 10 minutes, put up a bullet point. Don't read the bullet point, just put it up. Talk for however many minutes, then make a summary bullet point, put that up. I hate the people that put up a PowerPoint slide and then they just read through the slide. If you're going to read through it, don't put it up. Or alternatively, just put it up and don't read it. Don't do both. It's an absolute waste. I hate that. All right, that's my PowerPoint rant. Pinochet's helicopter tours. Hey, what's up? Railroading by juror. This argument works for jurors. Railroading by juror. This argument works for. What? I'm not sure exactly what you're getting at with that Pinochet's helicopter tours. If I'm interpreting it correctly, I'm taking that as you're saying, is it a thing for one juror to railroad other jurors? And no. And that's again, this all boils down for me to the fact that juror number one is not the leader. He's not the commander that everybody has to fall in lockstep behind him. He is the guy that he's the one that goes, all right, you're the one that has to say, we've got a verdict. You're the one that maybe in some jurisdictions has to read it. That's pretty much what the juror foreman does. Calls for votes. Doesn't have any special powers or wave or some sort of supreme executive powers over the rest of the jurors. All right, let's continue.
Online saying my new best friend is Jules. She's posting in chat rooms saying to one of the bloggers, check out the burner phone with regard to information we have about the Heart Institute. And they're making plans to go to dinner. I mean, at some point, just the appearance of the friend of the juror's wife sitting in close contact with the agent of the Kowalskis is wrong. And the idea
fuck that agent of the Kowalskis argument.
Unbeknownst to the defense and known to the plaintiff, that ultimately culminates in a motion that we brought, and I believe November
exactly,
6th,
Joel,
asking for the disqualification of juror number one. And Mr. Anderson, as you remember, went back and forth on it. I think I'd have to agree with this. You asked him, in fairness, Your Honor, do you want this as an appellate issue? And Mr. Anderson said, no, I'm going to substitute in the next juror. And then he went to Mr. Kowalski and said, they had a conversation. Obviously, we're not privy to what the conversation. He said, based on the conversation I had with my client, I have to go with his wishes and keep him on. The
Don't go that's what you do. And Anderson himself said, I should have talked to him at the beginning. Only right when I was getting to the decision time that I realized I hadn't talked to my client. Guess what? Anderson works for his client. Ultimately, the client gets to make those decisions. That is absolutely the client's right to say, no, which we saw clearly we saw in the Depp v. Heard trial, where Amber Heard was telling her lawyers to do things her lawyers clearly didn't want to do. And where she was always passing those little post-it notes to her lawyers, to the point where the lawyers had to tell her to stop sending them the goddamn post-it notes. The client is in control. The decisions are made by the client. The strategy, I mean, this is very, very generalized. The strategy is developed by the lawyers. What order to call people in, what questions to ask, but like the main decisions are the right of the client to make, unless he says, hey, I'll do whatever you want. You're the lawyer, you know better than me. But if a client says, I want to keep that juror, and his lawyer says, well, no, and gets rid of that juror, that lawyer has now stepped out beyond the scope of his instructions from his client. So it is absolutely right for him to say, to approach his client and say, hey, this is what I think, this is what it looks like, and have the client go, all right, thank you, lawyer, for your input, but no, I want to keep the guy. There's nothing inherently wrong with that at all. And I wish I was drunk. Hey, Jeff, currently getting ready for day drinks. Oh, well, congratulations. You probably deserve it, and everyone else is probably getting ready for day drinks during listening to this. Pinochet's helicopter tour. Thank you so much. You don't have to super chat your clarifications. Meant the railroading of Jan Sixers. All right. I thought it said jurors. I thought the six was a mistype. Yeah. All right. Sorry for the I don't know if it worked for them or not. Railroading jurors. I don't know if it worked for them or not. That's one thing that I haven't really been paying attention to, because it bores me, to be honest. All right, let's keep going here.
At that point, we believe it has to be clear that they knew that his wife was in the gallery. What jurors may have told them about what conversations she had, we don't know. But we're entitled to an interview on this subject to find out.
What?
Let me ask this. Assume for the sake of argument, I agree with you that from an appearance standpoint, or maybe the cumulative nature of the instances that you have laid out, suggest we need to have an interview. What type of parameters would you recommend be for that interview?
Okay, this is a little bit of a telegraph that this is something that judges will do to sort of tip their hand to what they're thinking. Okay, say, okay, let's just suppose that we do decide to have this. How do you want this done? So this is a little bit of a telegraph that he's leaning towards, for whatever reason, he's leaning towards a juror interview. So yeah, and then we'll see, I'm sure, a lot more of the reasoning, maybe as it comes out here, but I'm sure we'll see the actual reasoning why he's decided to go with an interview in the order that we're going to be looking at here at the end. So this is a little bit of a telegraph that he's leaning towards that, I believe. And he's saying, all right, let's just say if this goes down, how do you want it to go down?
Right. And Your Honor, honestly, I've never had to make this request in my 20 years as a trial lawyer. I will say I understand what we're asking for and the consequences of this. I completely understand the need to respect the judicial process and the jury process and not pry into their lives. I've never called a juror. Obviously, that would be improper and illegal. Their deliberations are theirs, but in a situation like this, with the totality of what's going on, we obviously need not just an interview to see who said what to whom, but the problem is either one of them could just frankly say, well, we didn't talk, and that can't be the end of the inquiry. I would like to know, since juror number one's wife and Jules were in close contact, apparently new best friends, texting about the trial, talking about boyfriends, I'd like to know what the communications were. And, again, I know it's a big request, but we'd like to know what text messages were going on between them. If the court wants to view them first and, look at them and decide, is there anything there? And you can tell us. I don't know any other way to do this, because otherwise, he, at least according to his own social media posts, he's been in contact with Mr. Anderson, who's told him not to say anything. So he's
Okay, that's sort of twisting things around. That's if anybody came to me, juror or not, and I was representing a client who was facing appeals, and if somebody came to me and asked me, is it okay if I say this? If I don't want you talking about anything, and you probably shouldn't talk about it, because I have to protect my client. And my client is not juror number one. My client is the Kowalskis. Yeah, I would be like, hey, don't. It's probably best for your own good, maybe, but also for the good of my client. Don't talk to people. And that's, again, the example I use is when we were doing the Zachariah Anderson trial, and Zachariah Anderson's brother and sister were here in my chat talking, and we talked about possible interviews and whatnot. And I said, look, right now, I actually said, you contact his lawyer and ask her what you should be doing, what you should not be doing. But I said, as far as I'm concerned, I don't want you lay low in chat, be in chat. Just don't participate, don't act, don't ask questions, don't answer questions unless you absolutely have to. Just lay low and stay quiet, because I wouldn't want anything happening to affect your brother's murder trial. And I mean, it is perfectly logical and natural for juror number one to come and say, hey, what's this? What can I say? What should I say? Can I do this? Can I do that? You say, no, I would prefer you didn't. Anderson probably prefers nobody on planet Earth ever talked about this ever again until the appeals are over. I would assume that that's what Greg Anderson really wants. So anybody that asks him is going to get told that same thing. But then again, at the end of the day, it doesn't matter who talks to who. So what if Jules talked to juror number one's wife? Whether or not Jules knew it was his wife, it doesn't matter, because guess what? It's not Jules talking to juror number one. It's not his wife talking to juror number one about the trial. It's all completely, they're under no restriction from the court at all. And there's no objective evidence that there was any improper communication coming along.
He's lawyered up to that extent. He's going to be, I'm not suggesting the plaintiff's counsel would ever say to him anything other than tell the truth. I'm not, but he's been lawyered up at this point and advised multiple times that if you say the wrong thing, you're going to throw out this verdict. So I don't know that we can just rest on the assumption that if the court were to ask a series of questions, did you consider any outside influences? Did you hear anything? If we get frank denials at that point, that would satisfy the inquiry.
That would satisfy the inquiry.
Social media, where our primary concerns came from social media.
Oh, it did. Where did it come from? What part of social media did it come from, Shapiro?
Communications were made between him and his wife regarding the trial, to see if communications were made between his wife and Jules or other agents of the Kowalskis, and to see what they're talking about. Because of course, if there's a text message that's going on between, for example, juror number one's wife and Jules that says, don't worry about this, he's going to vote for you, that would be massive, and that would be grounds for a new trial.
Yeah, but that never happened, did it?
The best for this would be the interview. We would certainly defer to the court to the grounds. We're not looking, we suggest it would have to be on the record with people with the chance to examine it. But we believe there has to be some type of an inspection, and the court can certainly control it. We could draft what we would propose as an order if the court were inclined. And I would respectfully suggest that we've more than satisfied our burden under Rule 1.431 with my sworn affidavit, with the evidence that we put forth here and more. And I would suggest that I would get with my appellate counsel, Mr. Altenburn and Mr. Hunter, and draft a proposed order that would encompass what we believe would be the scope, that would include not just an interview, but some type of an inspection of electronic devices.
Oh,
Thank you, Mr.
you just overreached.
From the plaintiffs.
He wouldn't admit he got all of his info from Reddit. He wouldn't admit that he blew his chance to catch the SS thing himself. And then I think he overreached there when he said, yeah, we don't want just you to ask the questions. We want to ask the questions, and we want to start scrounging through electronic devices. The purpose of the interview is to see whether or not the juror committed, whether there's any evidence that he committed anything from his own mouth. It's not a fishing expedition to interrogate him and hope you can trip him up and catch him or twist something in a way that makes it look like he did something that you have no evidence that he did. I wish I was drunk says I might not deserve it, but I'll look for a reason. Parentheses to day drink. you'll find one, I'm sure. Thomas Stratford says no evidence, just that horrific stench. See, I don't smell that stench. I'm afraid I'm gonna have to disagree with you there, because literally everything they put in their motion was what juror number one's wife did or said. She is under no instruction whatsoever to say or not say anything, to talk or not to talk with anyone, anybody, anything about the trial. She is absolutely as free as you are to post and say anything you want on any forum, any way, anywhere, anytime you want. She's in exactly the same position as you. And that goes double for Jules. Jules, she's not related to anybody. She can talk to anybody she damn well wants about anything she damn well wants in the courtroom, out of the courtroom, whatever. The only people she cannot talk to are the jurors. And there is absolutely no evidence, no hint, no whiff that she talked to juror number one. It's clear she shared a few words with juror number one's wife, at least, and whether or not she knew at the time that it was juror number one's wife is absolutely irrelevant. What boils down to the question, the only question is, did juror number one's wife have improper communications about the trial with juror number one? And the defense has not put on a single piece of evidence even circumstantial evidence to show that there was any improper communication between juror number one and juror number one's wife, other than, well, they lived together. So clearly they must have discussed this case. And if that's allowed to go down, then married people can never be on a jury, because you would just have the assumption that they talked to their spouse. And that's just utter nonsense. So yeah, I'm gonna have to disagree just a little bit. I don't see this stench, and we'll talk about it a little bit later. But I'm thinking the judge is probably in the same place. But let's do this, then jump right back into it. Tourette's Majestic, hey, what's up, member for 5 months? Thank you so much. And okay, maybe I got lost along the way, but who is Jules? I thought Jules was juror number one's wife this entire time. Is she not? No, Jules was here in chat. She was just attending the court, talking to people, being a trial watcher. Juror number one's wife is not Jules. Juror number one's wife is juror number one's wife. There was one day where, I'm not sure if it was the entire day or half the day, Jules can correct me, but Jules sat next to juror number one's wife in court. And she had allegedly, it doesn't matter if she did or not, sent emails or talked to other people involved in the trial and whatnot, which is absolutely perfectly okay. And from that, the defense is trying to insinuate and trying to make the case that somehow Jules was the agent of the defense team. I mean, which is just dumb. So, yeah, hope that clears it up a little bit.
Your Honor, if please support, we'd like to break up some of these arguments, because I was there, but the legal arguments would be handled by Mr. Elliott.
I'm going to try to keep us to one attorney per issue. Okay, so
To the extent the court then.
if I've got questions, I know how to ask. So, Mr. Elliott, let me just start. Isn't what the defense has put forward in their motions enough for us, from a appearance of impropriety standpoint, to go ahead and have a juror interview with some parameters to be discussed? I mean, isn't that what really we have to do at this point?
Your Honor, we would say no.
Why?
Several things. First off, and they've got several different components here, but all the stuff that's in the original motion is supposition, attack by proxy. They must have done this. They must have done that. This thing was on live the entire time. Everybody saw what was going on. They're assuming things that they can't prove, and we point out in our response. And we also point out at the very beginning, they waived all of that, because it was all available for them to see. We know from what we've submitted to the court Mr. Shapiro was online. We know his wife was extensively online. So if we're going to assume that wives and husbands talk, which is what they want you to do for the juror who was told not to talk with his wife, we have to assume Mr. Shapiro and his wife were talking, and he knew all of this stuff in real time that was going on, and they do nothing about it until after they get an adverse verdict.
Oh, that's an interesting argument. So we were just saying, oh, what we were saying here in chat and what other people were saying were, well, he's only upset that someone on the plaintiff side is talking to the media, or someone who supports the plaintiff is talking to the media. So, oh yeah, but he's not complaining. Shapiro's not complaining that his own wife is doing it. I like this argument that it's clear Shapiro's wife was in real time during the trial scouring through social media, and they would have known what juror number one's wife was doing. So if Shapiro's wife is scrounging through Reddit, scrounging through Facebook, scrounging through all these other places, she would have been aware of what juror number one's wife was doing. So why didn't she? And of course, because her husband is on the team, she obviously would have spoken to her husband about it. So why didn't her husband raise the question at that time? I like that. That's a good argument. If you're going to impute this discussion between juror number one and juror number one's wife because they're husband and wife, well, then Shapiro and his wife should have had the exact same discussions. That should be imputed to them, that she was filling in her husband as to what juror number one's wife was doing. So therefore, he should have raised it and he didn't, so it should be waived. I like that argument. That's a good, solid argument. I like that.
So all the stuff in the first one, I would say, is gone on that basis. And then we go through each of them and tell you and explain why. For example, the creature comforts. That was, contrary to what they represent, that was said before the question was asked.
That was a lie.
It's
Yeah.
also a very common phrase, as we point out. So each one of these things has a logical explanation. You can't put together 15 things if that's what they're.
That was a lie from the defense, that no one, juror number one had asked a question about creature comforts, and nobody ever had used that phrase. But it was in one of the expert witnesses' websites, when clearly, I mean, it took about 20 minutes for someone to come up with the day, date, and timestamp for the witness that had just used it a few days previously. So yeah, that was an outright lie by the defense, by the defense lawyers.
There are that have no significance and say, oh, now we've got a big conspiracy. Okay, so that's why I was in the first motion, gone because of that. The second one, with regard to the 2002 notice, over 20 years old, case law is very clear. That's way beyond the time to be relevant to anything. You also can't tell anything that went on from it.
I mean, what if, and I guess it's just a what if. What if it involved, I think it was right, HRS at the time and not DCF, but
Right.
HRS at the time. And he being juror one, harbored some view of HRS that he brought forward. Isn't that something that the defense would have been entitled to know about?
Yeah, we don't.
Why would we have asked the question in the first place on the questionnaire if that wasn't something that we were concerned about?
Your Honor, from what they've submitted to the court, they haven't gotten to the threshold issue of showing anything that went on. I mean, we don't know if he was the complainant or maybe he was subject of it, but we don't know anything about what was involved there. There's just no background. Plus, it's over 20 years old. Case law, we've cited some cases where things were much less time than that, and the court said it's not material at that point.
Yeah,
It's too early to be
20
material.
years removed is pretty
And of course,
remote
this is
and
not a case
irrelevant.
against DCF. If you harbored something against DCF or HRS, maybe his eye would have been directed toward them and not the hospital. It might have been good for them. So, this is all an after the fact, trying to get out of what happened. That's what this is all about. The juror 2 supplement on the writing of the lettering, I think the court has dealt with that. But if we're talking about using the letters, I have a demonstrative exhibit.
Oh, yes. Yes, he did it. He brought a Kiss album. We talked about Kiss. Oh, but okay, points off for bringing up one of the not so great Kiss Alive. That would have been a good one. But Kiss Alive 2, not the greatest Kiss album to bring, but there were many better Kiss albums that could have been brought. But yes, he brought a Kiss album because that was one of the first things we talked about here. It was, yep. So maybe they're just part of the Kiss army. That's what we brought up. Damn it. Should have been a better Kiss album. Oh, hell. All right. That is awesome. I feel seen because before we were talking about the nauseas, we were talking about Kiss. All right, let's go.
Okay, these letters are commonly used for a long time. Okay, it does not mean it's a Nazi symbol. From what I've read online, 2 of the founding members are Jewish in this group. So
Yep.
I think that should dispose of that. Then we got a new one this morning.
Devout
This is the first time
Jews.
that we've seen this. First time we've seen this. It does not, from what we can tell from here, and there's no follow-up. Here's a conviction. Here was a prosecution. Nothing like that. So we don't know if there was any kind of conviction on this.
What are we talking about?
We're talking about this affidavit you got this morning.
See, that's it. That's what I was saying at the beginning. The victim, or has he ever been convicted of a crime? There's no record of any conviction that I could see on that. If you're not convicted of the crime, you're not convicted of the crime. And the same with the 2016 incident. Are you the victim of a crime? Well, if there wasn't a conviction, it was only an allegation. And he wasn't a victim of a crime. He was a victim of an alleged crime, which doesn't seem to be reportable to me.
About a threat by apparently juror one's wife before they were married. It was before they were married. It's a threat by her son or stepson. Anyway, first time we've seen this, it does not show, there's no follow-up. There's not showing of any conviction. There's not showing of any physical harm, any physical crime being committed here. This is, again, just a lot of grasping. It's, again, trying to attack by proxy. Who knew who in the courtroom?
Doesn't matter.
Really? I mean, if this goes where they want it to go, you're not going to have any more married jurors because there's going to be a presumption. Every juror speaks with his or her spouse. So that's just too much reaching. As far as the materiality goes, they said, well, they didn't disclose, so we've met that. No. To your point, Your Honor, they have to show it was material. It's a 3-part test. Even if there was a blatant concealment, it has to be material. And when you don't ask any of the others, and they can't come in here and tell you, oh yeah, we asked everybody that listed this, we asked them. They haven't gone back, they haven't even done that exercise, I think because they know it wouldn't support their view. But
boom, that goes right back to the beginning of this, when the judge said, okay, did everyone else that checked this box, did you go back and talk to them? They couldn't even be asked to go back and do it. They said, we haven't checked that yet. So how do they know? How can they say that it was a material breach when they can't even go back and say, we checked everyone, we went back and we asked more questions of every one of these people that checked that box and we excluded them on that ground. They don't even know if they talked to everybody else that made that. So they're focusing on juror number 1 when they haven't done the same thing, or they're unable to prove that they did the same thing to other people.
But what really happened here is they didn't ask juror number 1 anything because he had a law enforcement background. They were happy to have a law enforcement person on the jury. They're generally conservative. They liked him until, I guess they didn't like some of his questions as things went along. We had the earlier motion, which was properly denied. So I'm happy to try to answer any of the questions, but we don't think there's enough here to do anything.
Well, assume for the sake of argument that I feel that there's a need for a juror interview. So
Okay, again, that's him telegraphing this. Okay, just assume that I'm doing this. How do you want me to do it?
make that assumption. All right. What is the scope? What are the contours for that interview?
I think it would be clear that you would conduct it, Your Honor. First off, we're not talking about the deposition. We're talking about the court conducting the interview. When I've been through this before, that's the way it's always been done. You don't let one side or the other have their way with a juror in the deposition setting. So you would conduct any discussion like that. It would have to be very limited. I mean, this business about I want to get into all the text and all the stuff, that would be unprecedented. Every time after this, there's an adverse verdict. You're going to hear people saying, "Well, okay, I want to get that juror's text with his spouse or his cousin."
Yeah, there's no way that's going to
Where are
happen.
we going to go with this?
There's no way that the
I guess
judge
you-
is going to
I
say,
think
turn
you
over
do.
all
I
your
mean,
cell phone
You ask
records.
these jurors every time when they came back, every time. Have they followed your instructions? Have they not discussed the case every morning? They all said yes. I mean, I don't see why an interview would be any different on that. I mean, but that would sort of be the scope of it. I mean, I don't think it's clear you cannot, that no one, court nor us, can delve into the jury deliberation process. At least,
I mean, I guess I'm with you on the thought process is probably something that we don't or shouldn't go into. But if we're talking about a alleged violation of the court's instructions. That's kind of extrinsic to the thought process. It's, did he receive information outside of the courtroom? And isn't that something that we should know about?
And he's already told you he did not, repeatedly. I mean, I suspect if you ask him again, he'll say the same thing.
Fair point.
And they're probably right about that, but I don't think that gives anybody carte blanche to go delve into everybody's personal information. I mean, again, all the things that they talk about in their first motion, which would lead to the interview, that they claim should lead to the interview, are all things that were publicly known. They are charged with knowledge of that. It was on the internet, all those things. They saw who was sitting in the courtroom. They saw this person and they saw the juror's wife. They saw them sitting here.
Well,
Yep.
To be fair, did they know who that person was at the time?
I think they knew who Jules was. That's pretty clear, and pretty clear from Mr. Shapiro's wife's posts. They knew that. And I have to assume Mr. Shapiro and his wife were talking.
Good point. Even the judge is like, let me think about that.
Anything else, Mr. Elegant?
Not unless you have any further questions.
Well, let's talk more about the scope and contours of the juror interview if we were to have one. So you're suggesting that the court is the one asking the questions.
Unquestionably, Your Honor. I've been through two of these before, and that's the way it was always done.
And I'm assuming here in open court.
That was not how it was done before. It was done in chambers with counsel present. I mean, you still have a juror anonymity issue, I think. But I haven't researched that. I'm just saying how it was done before.
My recollection from the papers is the defense have put forth that juror number one has identified himself publicly as juror number one.
Well, I think they outed him first, Your Honor, but I don't know which came first.
No, he outed himself first.
Okay, and so the court were to conduct it, and what are the limits?
I think you can add, I think it would be limited. I think you would say, there have been allegations made that you were communicating during the trial information that you were discussing it when I told you not to. Is that true?
Anything else, Mr. Elegant, you want to tell me?
I don't think so at this time. I don't have any further questions.
I don't have any further questions for you. Any very short rebuttal, Mr. Shapiro?
Any questions for me, Your Honor, in light of what Mr. Shapiro raised?
I'm sorry, no, I don't have any questions for you, Mr. Anderson. Now, I don't know yet what I'm going to do. I intend on resolving whether we're going to have a juror interview.
Okay, well, he does know what he's doing now, because the order saying that there will be juror number one brought in for questioning by the judge on January 3rd. That's we're going to read that order here in a few minutes. But people have been hard on Judge Carroll here for bringing for the interview, which I don't think is unreasonable under the circumstances. And as we'll see, he essentially sided with the plaintiffs in how to go about doing this questioning, because the defense wanted to question the juror. They wanted to basically interrogate him on the stand. They wanted to dive into his text messages and other private communications. And the judge didn't let that. So the judge is siding with the prosecution. I mean, with the, I keep saying prosecution. I've been watching too many criminal trials. It will side with the plaintiffs. He essentially sided with the plaintiffs in his ruling, which we'll get into. American Dreamer, I wouldn't say he's trolling the defense, because he's not going to be biased one way or the other, but I think he knows where he's going with it. And we'll talk about that when we look at the motion. Now I'm going to skip ahead here a little bit, just a couple of minutes, to where they get into the arguments for why they should have a new trial. And I'm not sure how much of this we'll watch, because that the juror number one misconduct was the main thing we wanted to look at here. So now we'll skip ahead. Got to back up just a bit. Yes, to the 44-minute mark. This is dealing with they want a new trial for alleged errors of law. And this section goes for about 45 minutes. We'll see how it goes. And I'll see how much of this we want to look at.
Remuneration for directed verdict, notwithstanding the verdict or whatever it's now called.
Well, exactly, Katie. The defense wants to go fishing and the judge, I
And
can't imagine he's gonna let
I'll
him do
point
it.
out, you've divided my very long motion into 3 parts of 15 minutes. And I can spend much more time than that, so I'm going to have to just identify fairly specific things that I think are most important that I would like to address in this first section.
I've read everything. I mean, I didn't read this affidavit yet, but I will.
And so I want to focus on the motion for directed verdict as to the intentional infliction of emotional distress resulting in suicide. I want to briefly discuss the insurance fraud motion for directed verdict, and finally the motion for directed verdict.
I don't know where the IJ report is in this.
On the intentional infliction of emotional distress causing suicide.
I don't know what time
I really
it's.
understand that this has to be
brought in at.
extreme and outrageous conduct that's atrocious to the point that it's no longer acceptable or cannot be acceptable in a civilized community. The plaintiff admits that no one event was enough to trigger that standard here and is wanting to use a series of things. And now is claiming, although it seemed to me during the trial and otherwise that there was no conspiracy or group of people planning this at the hospital. It felt that way at the time. But now they're just saying it was random people in the hospital that did these things that rise to the level that when communicated by her husband to her caused her to commit suicide. The first thing I want to argue is that my first jury instruction proposal to you was the correct standard, that a common law court expanding incrementally the common law should restrict this claim to one in which the intentional infliction is done for the purpose of causing suicide. And if that were the standard, we wouldn't have even had a trial here at all on this. And respectfully, if we are to go beyond that public policy to something that's even a substantial factor ends up being
That's a
matter
good
that
point.
Causes 100% responsibility under an intentional tort, or we can't claim that she was comparatively negligent. We can't claim that we're entitled to contribution from DCF or anyone else. If that's to be the law, that should be the legislature that does that. That's a step beyond what a common law court should do. So I'm asking first and foremost for a directed verdict because that was the standard that should have been done here. Now, if you reject that, then we go on to how we actually tried this case. And what I've pushed repeatedly is to, because the pleadings were never a plain and simple statement that said, on this day, this happened and it was extreme and outrageous conduct. And on this day, this happened and it was extreme and outrageous conduct. Instead, they tell their story with lots of adverbs. And so the question has always been, well, what are these things? What is it that's so important that it causes this to be intentional infliction? And in their response on page 84, 85, they say that the defendants ignored Beata's request to have Beatty removed from Maya's care. Well, that was the negligent supervision and negligent retention claim. You're quite familiar with what the evidence on that was. There's nothing in there that rises to extreme and outrageous conduct at all. She was the most experienced person with DCF cases, and we kept her on this because it was a complicated DCF case. That's not something that's not tolerated in a civilized community. The next one is then that
Well, that's only when they're not calling her the ketamine girl.
Maya in the chapel. Now, we've been through that multiple times. You know that that's not the evidence. You didn't even allow punitive damages on that, let alone to go to the jury on this. So that's not proven. It's a distortion of the evidence. And it's certainly what is proven that didn't even allow for punitive damages is not enough for this count. Third, they say we refuse to allow
This what?
visitations by phone and FaceTime.
Okay, dude, you need, just a suggestion. You need to work on your pronunciation of count. Yeah. Dude needs to work on his pronunciation of the word count.
And it's certainly what is proven that didn't even allow for punitive damages is not enough for this count. Third, they say we refuse to allow court-ordered visitations by phone and FaceTime.
Awkward.
Isolating
Let me ask you, because on punitive damages, there has to be that next step of, upper management, knowing, ratifying, whatever the statute says. Are you suggesting that the punitive damage standard is engrafted onto the intentional infliction of emotional distress cause of action?
What I'm suggesting is the Supreme Court has said that it's not enough for it to be punitive damage level. It needs to be more than that to constitute intentional infliction of emotional distress. That's from the very first case discussing this that they've said that. We've said
Especially, okay, that's kind of what he's doing. He's saying that the judge erred in allowing it to happen. So he's arguing why it was an error for the judge to rule the way he did.
Either directing or condoning, ratifying the specific conduct, as opposed to someone who's not as high on the food chain doing it.
I don't know that I'm necessarily saying that, but what I'm saying is that the testimony from Maya about what went on in the chapel was not molestation. It was she put me on her lap and she hugged me and I didn't want to be hugged. That's not molestation, and that's not conduct in that context that's extreme and beyond what a civilized community expects. She may have been unwanted affection, but it is not enough for this tort. And the next one, they say that we refuse
Unwanted
visitation by phone and
affection?
FaceTime. You heard various times when they were on court-ordered visitation. You've heard how complicated it was for us to try to comply with the Chapter 39 requirements on this. And as to FaceTime, they're flat out wrong about this. They've made claims that after December, I think it's 28th, that we didn't do this. But if you look in the record at Exhibit 1001, pages 1985, 1982, 1981, 1787, or in their Exhibit 2277-628,
2277-628.
628, you will see multiple records discussing the difficulties we were having and that these things were taking place. That in fact, we have the one from page 1985 shows that these are taking place on January 3rd. They took place twice on January 3rd. There was one on January 5th, the day before she committed suicide, but that are all in the documents. And the earlier documents show that at the very beginning of this, in December 30, 31, they're fighting about, well, is it 1 hour's worth of time or half an hour's worth of time that she gets in these? And she wants it moved from one time to another time, and they're trying to accommodate her with that, and they're working with DCF on that.
Really were they trying to accommodate her?
There's all
Really?
kinds of evidence that shows that the FaceTime stuff was going on in that time period, and there's no testimony I can find from Mr. Kowalski or anyone else that says that's not the case. One of these says that Mr. Kowalski himself was present for one of those calls, that he was in the hospital and that her mother was at home. So there is all kinds of evidence on that. Then we have that we refused to facilitate family therapy sessions ordered by the dependency court. Now, you will recall that the judge in the dependency court sometimes didn't get his orders very clear. We had to actually clean up a couple of things. But one of them was, he said she couldn't be in the hospital. Then later on, there was a spot that said, well, the family can attend therapy sessions. It was an ambiguity in the order. If it was to be cleaned up, it was to be cleaned up by the judge in the dependency proceeding. They never asked for that. The fact that we didn't honor this is not something that is extreme and outrageous conduct on our part. It just doesn't come close to that.
He's definitely talking like the in-house counsel for the hospital, using terms like my doctors, we are doing this. They're saying my client because he works for the hospital. He's actually speaking on behalf of the hospital. So that's I find the turn of a phrase interesting there, the way he's wording it, which is, I mean, there's nothing improper with that. I just think it's interesting. He's saying we, us, our, when he's talking about the hospital, because he works for them. He's their in-house counsel, clearly. Or if he's not, I mean, okay, he's probably not in-house. I'm misspeaking. He's retained probably, I would guess, exclusively. I don't know if he works actually for the hospital or if he's just retained exclusively to deal with the hospital issues, but this is a guy who does so much work with Johns Hopkins that he identifies as part of them. And wow, Mathis agrees. The IJ report and sanctions are at the very end. If someone can throw me up a timestamp, yeah, you don't have to super chat it. Just like throw it up somewhere where I can catch it. Then we'll check it out in the end. But D Watt, for some reason, bringing a $99 heat. Thank you so very, very much for that. That's crazy. D Watt, you're a huge supporter of the show, and I appreciate the generosity more than you can possibly know. Thank you so much for that. We'll give you the foghorn. You get the foghorn. Thank you so much. And that triggers several things that we have to take care of real quick here. Well, that wasn't one of them, was it? That was the opposite of what I wanted to do. So let's put that back. And again, thank you, DWAT, and all the other people that are supporting the show this evening. I'm humbled. I'm always humbled by your support and generosity. We want this to happen. Hang on. I'm adjusting as we speak. It's something for those of you that are just joining us. This is just an achievement that gets unlocked when we get to the $100 super chat mark. It's that time, ladies and gentlemen.
Release the hose.
We gotta zoom out a little bit on the dogs. It's doggo cam. We've unleashed doggo cam, so to speak. Let me work this out here. Zoom out a little bit. And there we go. Those are my two dogs, Strawberry and Yoda. Oops, now we've gone down too far. There we go. They're just chilling asleep, sitting next to the space heater. All right, thank you so much, D. What, for pushing us all the way over the edge, and then a whole hell of a lot more. Strawberry and Yoda have joined me as my companions for the evening, and that's it. Let's jump back in. Oh, we're well past the halfway mark. So I think we need to check our like and subscribe poll. We've got 769 concurrent viewers here right now, 442 likes. Come on, people. We can do better than that. We got like 300 of you haven't done your job. While I'm taking this 30-second break, get down there and click that like button. Make sure you like this. You've been here for more than 30 seconds yourself, so that you clearly like it enough to stick around. So hit that like and subscribe button. Do me that favor. And if you have subscribed, please make sure you're still subscribed. Then take our like and subscribe poll, which is, how do you feel about juror number 1 being interviewed by the court? So far, 53% of you said you're angry. 18% of you say it's understandable. 21% of you say make it make sense to me. And 8% of you said you don't care one way or the other. All right, we'll see how that's with 690. How do we have 690 votes and only 466 likes? That's like 250 of you are cheating your asses off. Take the like and subscribe poll after you actually like and subscribe. You cheaters. All right, get down there and take care of that. And we have also just been gifted 5 Legal Vices memberships by Lynn Berry. Please give Lynn Berry a super special thanks if you were one of the recipients of that very generous donation of 5 Legal Vices memberships. And stay tuned for our first all members membership chat for the new year. I'm going to start doing them monthly like I promised to do, and I haven't been doing for a while. Well, that'll be probably coming about 3 weeks from now. Our first Legal Vices members only membership stream of 2024. And Rain Man YYC, I'm so disappointed that J Hatch didn't get a Christmas visit from Krampus. That's actually funny. I like that. That's funny. All right, thank you so much for that. Let's get on with the show here.
And finally, they say we ignored Beata's medical decision-making rights that had been.
Why the fuck can't he pronounce her name right? How hard is it to say Beata? He's called her Beatty, Beata. At some point, you got to feel like he's doing. I mean, he's only had what, 7 years to learn how to pronounce her fucking name. At some point, he has to be doing this on purpose, which should be called out. The defense should be called out on this. The plaintiffs should make a big stink about it. All right, it's aggravating.
Reserved for the dependency court and tormented Beata further by threatening to remove Maya's port.
Well, he can get it right.
Going to the port, we suggested it would be a good idea. I think Sally Smith did the same. And Beata refused to have it taken out. That's all there was to that. No one was threatening her with anything with that. As to the medical decision rights, she did retain certain medical decision rights, including the one not to take out that port. But she also was in a DCF proceeding that was accusing her of medical child abuse because of the treatment, including the ketamine that she was doing. So the notion
he can't
that she had a right to say, I'm going to do whatever I want, even though there's a DCF proceeding going on, that we should be compelled to do that as something that no one would not honor in a civilized community. That is absurd. So the things that they have listed here don't fit that. I could go on with the rest of them, but I'm going to run out of time. They were things like we wanted an open door when her male lawyer came to the hospital without anyone else, and he wanted to be in the room with her alone. There's a laundry list of things that they say this way, that we negligently changed her diagnosis from CRPS to something else. And the last thing that they talk about is that, they talk about that we intimidated her because of all the things that occurred on January 6th, none of which she knew about. That is undisputed. So these things, even if you're looking at Maya, it may not be enough for intentional infliction, but what they're claiming is that these things, when communicated by Maya in some fashion, we don't know the details, to Jack, who took them home and told them to his wife, got her so upset that Jack didn't come back and tell the hospital about it. Jack wasn't even concerned on the day she committed suicide that she would commit suicide. But we were supposed to have foreseeability to know that what our people were doing, not as a conspiracy, but in this random approach, was enough that we caused her suicide. And I am sorry, that is just not the common law of the state of
Well, then why did one of your staff predict it?
On that claim.
Why did one of your staff predict it if it was unforeseeable? It was clearly foreseen by at least one person on your staff, you
But it was a claim
dickhead.
of intentional fraud. And that is in terms of what the jury was told that there was a fact question about whether we intentionally defrauded them with the insurance. Now, I put in recently just the testimony from Mr. Kowalski about the insurance. There's just a few pages of that. And you know that they didn't actually even put in the bills to begin with. They put in the 3 years of medical processing by Aetna. They never called anyone from Aetna to say there was anything improper about the billing.
Well, Don, what they're doing is they're explaining why the jury came to a wrong conclusion and why the judge improperly ruled on certain motions. So they have to talk about what they talked about at trial.
On a bill with the intention of defrauding somehow Mr. Kowalski or the insurance company when the insurance company is not claiming to be defrauded. And that person knew that it was a false statement to defraud them, even though if you look at the medical records, we were providing physical therapy, occupational therapy, cognitive therapy. They're complaining we didn't do enough cognitive therapy, but those are all things that would be done for CRPS as one of the options of a diagnosis. When you go beyond that, and he says, well, it's because I didn't pay a copay. He presented no proof, and he admits in his testimony he has no proof of that. He has no proof we sent him a bill for a copay. The statute of limitations for trying to enforce it by a lawsuit has long since expired. There's no evidence of that. There's no evidence that the deductible was somehow spent on this as compared to everything else that was paid. Those bills were predominantly for 100 days of service in that hospital that we were required to do because the court wouldn't let her out of our hospital. So those things are simply not proven here. As to the extra insurance costs, the only thing he ever did was say that his COBRA bill was higher. Well, that's because his wife no longer had group insurance. It has nothing to do with anything on the coding of a bill from us. So we're entitled to a directed verdict on that claim. Now, finally, on the individual claims for punitive damages, I'm going to start with, I've got limited time, so I'm just going to aim first at the first week. In that first week, and I'm looking at the first stage of the punitive damages. You heard the doctors, what condition she was in. There's no dispute, first day she was in tremendous pain. She was sent there by her doctor, and they began treating her in the emergency room and in the PICU and doing things that they believed were in her best interests. As Dr. Elliott explained, he was doing things pharmaceutically with her that he believed if he put her out the door because the parents wanted her out the door, it would be dangerous to her. Now, maybe he's right, maybe he's wrong. But for punitive damages, the first front end was it unreasonable and unwarranted not to send her home with mom? Keep in mind that mom's email, which is the email.
That's probably I would not be surprised.
She explains that she had this interview the day before with Dr. Smith. So she knows by then that Dr. Smith, by the way, is not one of our agents. But in that, she's explaining that she didn't want to take her home.
You mean Dr. Smith that's listed as a staff member on your website to this day? You mean the one that came in wearing a hospital lab coat with her, with your tag on it, that had a staff card issued by you that said she was and didn't disabuse anyone? Yeah, stop that. You can just stop that bullshit argument right there.
But she was really trying to get her to go see Dr. Hannah, that she needed to have her in an ambulance to go see Dr. Hannah. So for a chunk of this time,
she's still listed as an active staff member on Jay Hatch's webpage.
From an intentional misconduct,
she's still doing it.
Is whether we had
they're still
actual
doing
knowledge of the wrongfulness of their conduct and the high probability that injury or damage to Maya Kowalski would result. And despite that knowledge, intentionally pursued the course of conduct resulting in injury or damage to Maya Kowalski. There is no evidence that the doctors in the emergency room or in the PICU fit that standard. You heard from all of them, they don't fit that standard, without even getting to the fact that the level of management above this and knows about this front end, from the evidence at least, they're relying upon the fact that these doctors are on committees for the hospital for management. They're entitled to a directed verdict on this one. It's the same as to the EEG room and as to the photographs at the end when you look through those things. Under the evidence and the law on this, they're entitled to a directed verdict. Now, I've got a reserved motion for directed verdict on the issue of specific intent. And I'm hoping that I'll try to do that in the damages part, so I don't run completely out of time here. Thank you.
From the plaintiffs.
Thank you, Your Honors. Any in particular you would like me to start with?
I think the one that Mr. Altenburn was hitting the most is that the conduct that was discussed at trial did not rise to intentional infliction of emotional distress relative to the Beata Kowalski suicide.
Okay.
Yeah.
Let's start with
I
that.
mean, I don't think you need to go to the wrong standard. That issue, I've.
None of the other jurors have
addressed and
talked as
ruled
far
on.
as I know.
You give them two different options. Okay. And
Well, I think Mr. Altenburn first wanted me to come to the conclusion that the hospital had to specifically intend to cause Beata Kowalski to commit suicide. I think that is where I think Mr. Altenburn wants me to go. That particular issue, I don't think we need to address, but his next argument about the quality of the evidence
Yes.
is insufficient.
Okay, it is sufficient. And
How so?
what you heard is you heard talk about one little thing here, one little thing here. Pages 2 to 5 of our response, we list many, many things that the hospital, using that generically for a moment, did over time to Maya Kowalski and her family, and of course that impacted Beata Kowalski. We do not say that there was not one event that caused the suicide. I don't think we say that. I mean, if there was one event, and what we do think it was a series of things. There were a series of things that led to this. The one event might be the photo taking. And if you look, they make a statement in their memo, and I'm not sure we corrected this, that Beata didn't know about the January 6th photo session. Well, that's contrary to Jack Kowalski's testimony on October 3rd at page 138. He says he told her about the videotaping, told her about the photos. So he testifies to that. That's in the record, and the jury's we get to assume that the jury believed that. Okay, so she was told about that. We're talking here about the mental and physical torture of a 10-year-old girl for 3 months. This goes on over a long period of time. To say, oh, well, the doctors, when she first came in, they weren't doing anything bad. Risk management was involved from day one. You can see that in the medical records. Risk management, as Beatty testified, instructed her to do these things, instructed her to videotape, instructed her to take the pictures, okay? And we have a detailed discussion in our memo about—
The videotaping and the pictures occurred after the first week in the first
Right,
claim
yes.
of false imprisonment.
Right, but during that first week, it's not just a few doctors at the beginning. The risk management is involved from the beginning in this case. As I said, we list the events that went on. It was, as you laid out, 3 periods of time. It stayed to that.
Her name is Beata. She's from Poland. It's a Polish
I
name.
mean, I'm not going to try to go through all those things. They're in the memo. We've addressed them. And when risk management is involved, that is the hospital. Okay, I know they want to say we staffed it with lower level people, but in evidence.
Yeah, Mr. John says maybe we should start teaching civics in school again. Yeah, maybe we never should have stopped.
Under 2802, Exhibit 20, there is a chart of the makeup of the hospital. This is in the record. We've got some extra copies if you were the
There you
counsel would like
go.
one. But you see above risk management, above that is senior counsel Crane. Okay, so risk management is under the auspices or reports to Crane. Right above her, she then goes directly to the chief executive officer of the hospital. Okay, so as we point out in it's about a 5-page discussion in the memo, Florida law and federal law and the Joint Commission that they voluntarily agreed to require that the hospital be responsible for everything that happens there, everything. Okay, we're not talking about just supervision. We're not talking about just training. They're responsible for it. It goes up the line. Okay, and this chart shows how they were reporting up the line. So they are charged with the knowledge of that. That committee, risk management under the senior counsel Crane, is directing these things to be done: picture taking, videotaping. They could have brought her in to testify. Oh no, that didn't happen. They were rogue.
Yeah, this is the
And
appellate
frankly, even
lawyer.
if they had done that, they're still responsible. If you work through the analysis there, they are responsible for what happened. So if they weren't doing what they were supposed to do in terms of letting people know what was going on, that's liability of the hospital. And when we get to the punitive damage part, that is, they're either under A and B for approving, ratifying, etc., or they're under C for the gross negligence and not knowing what's going on. So either way, they're going to be liable there. And it sounded to me like the intentional infliction was blending over a little bit into punitive damages. But if for either one of those, the hospital and the higher up people either knew or they are deemed to know under the law. So the intentional infliction, the items that went on, we say were sufficient. You've ruled that before. The jury obviously found it sufficient. We don't think this is a matter of law to be removed from what the jury did. If there are any other questions on that, okay. On the billing fraud, they listed hundreds of times that they were billing for CRPS. I still don't know that I've ever heard them say, yes, we acknowledge she had CRPS. I don't know that they ever said that, did they? I mean, I know you asked them about it. I don't know that you ever got a direct answer to that. They seem to want to walk the line on that. When you bill for something that you're not doing,
that was something that was pointed out as well. They've sort of walked. They have one foot on either side of that. Did they have CRPS thing? They refuse to say the words. They act like it. They behave like it. They behave like they're finally admitting it, but they won't say the words. So yeah, that's a very good thing they're being called out for right there. And Matthew agrees again. €5 super chat. Sorry about that. Dr. Majors put Dr. Sally Smith was heavily involved in the treatment of Maya into their records. Whitney confronted Dr. D's nuts with this. End of argument. Oh, there was much more to it than that as well. I mean, that was just one thing. There was so much brought in about how, she's saying take them off. Anybody says take someone off medication, that's treating someone. That's treatment. I mean, there were so many instances where she was treating Maya, presenting herself as someone who's treating Maya. That is such a non-starter for me. She was clearly involved. She was clearly, if not an actual employee of the hospital, very, very much so an agent. And Sebastian Mueller has gifted 20 Legal Vices memberships. That's a big in there. You get a foghorn. Thank you. Thank you so much. If you were one of the 20 people who received the gifted Legal Vices membership from Sebastian Mueller, please give Sebastian a super, super special thanks. That's, again, very incredibly generous of you. Thank you so much. Chopper with an interesting comment. I have a feeling that Maya is not the only one who will walk away with a lot of money. Oh, there is already case number 2 for a very similar incident against J Hatch underway. But yeah, you're probably right with that.
that's fraud. Now, did it cause any damage? Did it cause any damage? That's why in the closing, the request for nominal damages, because of all the other things going on here, there could have been a person who would come in and testify about this, this was too much, this would have been that much. They didn't put one on either. Okay, so that's why we suggest that a nominal damage is appropriate there. Let me flip back. One thing I forgot to mention, and I even had it tabbed, that the jury did hear. We talk about where's the evidence that they again, we don't think they had to intend the suicide, as you real. Where's the evidence that they were so callous and so forth? How about trial exhibit 2175-004 from the text messages of Dr. Voss? Learned today that Ketamine Girl's mom committed suicide yesterday. Sorry to say my prediction was correct.
Yep, there you go. Boom. Oh, we had and that one text shoots a major size hole in the J Hatch ship well below the waterline, as far as I'm concerned, because that was the whole thing. He was just arguing, how was this predictable? How could we possibly know that we would say or do something to Maya that would cause her to tell her father would then tell her mother, and then her mother would get upset, which the father wouldn't come back and wouldn't report to the hospital, and then eventually she got so upset she killed herself. That is so remote. How could we possibly foresee such an event when this is what we were talking about? Here is a text message from someone in the hospital saying, as I predicted. So it wasn't, if your risk management team can't do it, you can't just, some low-level staffer in your hospital predicted that this would happen. So it's clearly foreseeable to at least somebody in the hospital. So yeah, this is one of the definitive statements as far as I'm concerned. And I've said that since we first learned of that text message. That goes straight to it was foreseeable because someone in your employ predicted it happening. So clearly it was foreseeable.
You have a medical staff member predicting the death of a mother of a patient there. And why didn't they do something about it? Okay. Does the court have any other questions on anything else on the DV?
No,
Then I think I'm done. If anybody wants, you have access to this chart, I know, but if you,
it's in the file.
yes, I know. Thank you, Your Honor.
Any very brief response, Mr. Altenberg?
I think it must be confusing what Mr. Kowalski could have said about the videotaping in mid-October with what happened on January 6th. There was no evidence. It was very clear at the end of this case that she had no knowledge of the photographs that were taken the day before she committed suicide. Maya didn't talk to anyone about them, and they were back in a storage closet still in a camera at that point in time. There's no knowledge of them. As to Dr. Voss, we've been through this. You heard her testimony. This is, first of all, it itself is not extreme and outrageous conduct. It's after she's dead. And it's a text message type discussion between two doctors. And she has explained, there's nothing that she reported or put in the medical records about this. The medical records show the mom was suicidal or expressed that she wanted to go to heaven, I think, that day, or maybe that Maya did, and that the people at the hospital offered to help her with assistance to get help from someone else, which she declined. That's all that's in those records. And as Dr. Voss explained, she was saying prediction was maybe a bad choice, but what she was saying that she had thought about this because she knew about something like this 20 years before when she was a resident.
Oh no, it wasn't a bad choice of words. She says, as I predicted. That wasn't just a slip of the tongue or a slip of the fingers, I guess. That wasn't just a bad choice of words. That was a specific statement. I saw this happen before, and I could predict it would happen again in this case. So yeah, that's a very specific statement. You can't write this one off as some sort of mistyping or misspeaking or a poor choice of words.
Respectfully, I've never thought that was relevant to much of anything, and the prejudicial effect of it is far more
Because you're an
clear
idiot.
than the probative value of it as to that particular claim. As far as the things at the beginning of their response, I invite you to go through those and take a look how many are negligent things, how many are things that you can look at and say are not accurate parts of the record. They don't support it any more than the ones they specifically used when they were addressing the particular one. There's no evidence on that in this case. Now,
I'm sorry.
go ahead. I'm sorry.
Yeah, were you finished with your rebuttal? Because
Yeah.
we're then going to move to the next topic, and I'm assuming you're
I'm standing here ready.
okay. So what we're going to do is we're going to do the next topic, which is the motion for new trial, which is exclusive of the alleged juror misconduct issue. After we do that, we will take a morning break. So Mr. Altenberg, you have the floor.
And I'll try to be shorter on this one. I want to save a little more time for the damages part because it's complicated. But on the motions for new trial, obviously on intentional infliction of emotional distress causing suicide, my argument would be if you saw some tiny amount of that, there's still the manifest weight when you analyze what the law should be on this is that verdict was just off kilter. The fact that it's off kilter on damages on practically every line kind of demonstrates that this jury was involved with a prejudicial effect and various things that got them to go off from the evidence. And so a manifest weight analysis,
did they really?
I think it was a directed verdict, would stand on that particular count. I think it also would stand on some of the other counts, and I've argued those to you as well, but I'm not going to take time here today to argue those as well. I'd certainly, the insurance count, I just don't think there's any evidence there to prove that there was any.
Well, you don't think there was evidence, but guess what? The jury did.
The nominal damages were not an element in that, and they needed to prove detriment to the insurance company financially. They never did that. They never brought in anyone to show that number had any impact on that. So that, if not a directed verdict, ought to be manifest weight. Now, we also moved for a new trial because of the Chapter 39 issues. And I do believe that is important. We wanted a broader immunity, and that was resolved on sovereign immunity, on summary judgment ahead of time. So I can't really re-argue that we couldn't get the broader immunity, but I will be arguing that later on in a different court. But here, there was a litigation immunity for things that went on in the DCF proceeding that kept out testimony about that. But it got to the point where we couldn't talk about ramifications of that proceeding. I mean, this woman committed suicide right after a hearing, and we couldn't really go into the details of that hearing or the fact that she's upset about having a hearing a month from now that she may lose her child to foster care, it may impact her license, the whole 9 yards. None of those things could we really get into as to the stresses that were on her.
Well, but let me ask you this.
Yeah.
Because, in the years leading up to the trial, the defense kept saying Chapter 39 immunity, can't. But then at trial, the defense tried to present a lot of stuff that happened in the dependency action. I mean, that's what the defense tried to do.
Mhm.
So, I'm trying to understand, it seems like I'm supposed to exclude everything that the hospital wants excluded from the dependency action, but then allow the stuff that from the same dependency action that the hospital wants to use. I mean, how am I supposed to draw that?
Yeah, there's the judge again telegraphing. You're cherry picking your issues. You cannot have it both ways. You can't say only let this part of the hearing in, but keep this part out. You want the stuff from the hearing in, or you want it out. Take your pick. So how am I supposed to choose what to put in, what to leave out?
Line, and I think I kept talking about, this is where I was drawing the line.
I know,
And that line I tried to draw as clearly as I could, but knowing the facts in this case were difficult, I admit.
the line is that no one could rely upon testimony on anybody's part to make someone responsible for something or the like. This is not going to be evidence that could be used to prove liability. What we were trying to explain, and repeatedly, is that on what's going on in Beata's head, why she is upset, why she is truly upset, it's not because of the testimony in there, but the fact that it's ongoing and that they're accusing her of Munchausen's in the proceeding by the state, and the state is accusing her of medical child abuse. And she has hearing after hearing there. She's got lawyers there. All of this is going on. And, she wants to see her daughter in the courtroom. And they basically have some understanding of that. But when we're on this, who caused her suicide? I'm sorry, but and it was really hard. It's nice to have a jury instruction that says we're not responsible for 100 days, but to try to get the jury to understand all the 100 days of things that are going on unrelated to the hospital that were related to the DCF proceeding. That's what we couldn't get into. And, I know in your head you were having a hard time on that distinction, but those were things we should have been able to talk about, because those were things that were really getting her very, very upset. Those were things that show up in her suicide note. And we should have been able to expound upon those things. We weren't allowed to do that. And that, to me, is a very important thing. With limited time here, let me move on to two other things. The next one is that with Dr. Smith on the medical negligence, the issue is whether she's an apparent agent. And again, we have the email from Beata Kowalski to herself. It looks like it was going to go to Dr. Hannah, but it never did. It went to her and to her husband. It clearly explains that she understands exactly who this woman is by the 11th of October. Now, apparent agency is not that complicated. It's a doctrine that says, if Joe is negligent and harms me, and I let Joe do something that harmed me because I thought he worked for Chris's Lawn Care, then Chris's Lawn Care is on the hook if they're the ones that allowed that to take place. It's that he's not a real agent, but the plaintiff relied upon that person and I got hurt. That's the theory. That's the theory when it's the x-ray room that is in the hospital that looks like it's a part of the hospital, but it isn't. Now, Dr. Smith came to the hospital, but before that very first day was over, she knew full well that she was there as a CPT person. Now, they probably say, well, she can be the CPT person and she can be your agent all at the same time.
Yeah.
That makes no sense here.
No, it doesn't. It makes perfect
What
sense.
they were allowed to do was they did this and they did that became Dr. Smith in all of her capacities along with the hospital, and we weren't allowed to show even the report that Dr. Smith gave to the court and made available in a hospital on these things. But the evidence had to be that Dr. Smith did something that was treatment that harmed this child. And she may have impacted by convincing DCF to file the proceeding, but she wanted to take the girl off drugs. Well, everybody did. Did that do her any harm other than ketamine? No. She wanted to take out a port, which Beata wouldn't let us take out. I mean, there's no evidence, A, that after October 11th that she was in any way an apparent agent, and B, there's no evidence that she did anything that was negligently harmful from that point forward. So other than advising us to call the hotline, she didn't do anything more than that. So I don't really understand how we got to this point. And from the way the jury reacted, it clearly impacted them on the medical negligence claim because they interphased the two proceedings, the CPT proceeding and our proceeding. And finally, on count 14C, the negligent training, it should have come out before trial, should have come out at the end of the case, at the end of the plaintiff's case. But what happened, they dropped it down to negligent training, which is not a part of the medical malpractice case. And I told you that that evidence could, there could be some evidence marginally relevant to punitive damages, which I think is true. I don't think there was much of any there, though, because the punitive damages were for not letting, perhaps not processing an against medical advice request to leave the hospital properly. Maybe they weren't adequately trained on that. Dr. Courtroom didn't say a word about that. He didn't have experience in that. Maybe it was because when the doctor sought permission to take the videotape in the EEG room that the little girl would know nothing about, that maybe there was a better process to do that. Maybe there should be more training on that, but that's not what he testified about. What he testified about was the whole structure of the hospital was wrong. Well, that wasn't relative to anything that was alleged in medical negligence. It wasn't relevant to the training, I don't think, but it became a big feature of this trial right down to the end when we had all the problems at the end of this case. So the fact that 14C went to trial ended up being very harmful in this case and would warrant a new trial. The last thing I'm going to mention is
He's not very
I do
convincing.
believe that Dr. Newberger was allowed to say things that were very harmful in many of these claims. He was a child abuse expert, and he was allowed to talk about conspiracies and the like. We did object to that. You overruled the objection. And their argument is that we waived it because we didn't object again. I'm sorry, you don't have to keep objecting over and over again. We did object, you ruled on it. They then made the decision to play that video to the jury, knowing that if you were wrong in that ruling, that it was going to be prejudicial. They did that, and we're not in a spot where we're obligated to do multiple objections, especially when you remember how hard it was to get anything done between 8:30 and 9:05 every single day. The more we had done that way, the grouchier you got, with due respect, Your Honor. So,
There was more than one or two objections during the meeting.
so that's what I have on new trial. Thank you.
Mr. Elliott.
Well,
Thank you, Your Honor. Sort of to start off, I guess we'll go in the order. Let me ask again, anything you want me to particularly address, please let me know as I'm going along.
Yes, sir.
Okay. Litigation immunity. And there was a statement about the January 6th hearing, and this is what did it. Well, January 6th is also the day of the photos. And maybe I wasn't clear before. The October 3, 2023 transcript of Jack Kowalski is what I'm referring to. I wasn't saying that he told Beata this in October of 2016. He tells her, did you tell Beata what we just talked about? And I say this, the photographs that had been taken of her, the video that had been taken of her, the witness, yes, I did tell her. That's page 138 of that transcript. So we have direct evidence in the record that Beata did know of those photos. Okay. Your Honor, kind of like you said, they want to talk about some things in DCF, but not other things.
Yep.
In the proceedings. We would have liked to talk, and we offered not to talk about DCF at all, you'll recall. We made a motion on that, and they didn't want that. Okay, so, because they wanted to hear about immunity. They wanted the jury to hear about immunity. Well, that's a litigation decision. But if we were going to talk about more of DCF stuff, we would talk about their involvement with DCF, how they basically prosecuted the case there.
yes, they
The hospital
did.
Involved doing that.
Hunter was up to his elbows in that.
Order. A question about good faith. The couple cases that you acknowledge you had to follow, didn't even talk about good faith. Well, we would have said a lot of things about good faith if we were going to get into the DCF proceedings, but we didn't. It was stayed narrow. I think to come in now and say, oh, well, we didn't get to do everything we wanted is a little late. On that day, again, tying into the DCF, Beata sees her daughter in a wheelchair. This is a 10-year-old who, among other things, was forced to defecate on herself, treated horribly. They just downplay this. As we say at the beginning of our response, they just don't get it. They don't get how bad what they did to this little girl was, and for her mother to see it, and then to hear about it when she couldn't see it and couldn't even comfort her daughter.
Yeah.
As far as Dr. Smith's negligence or apparent agency, it's a little bit moot or academic in one sense, because there's a question on the verdict form about medical malpractice from the other doctors, and that's answered yes also. So, but to stay with Dr. Smith for a minute, to say that she didn't have any involvement, I mean, here's a note from risk management file Trial Exhibit 2277-068 about the videotaping. And Dr. Smith is all over it, Dr. Sally Smith.
Yep.
She's involved in this. The other thing is that the question of, well, maybe Beata knew she was a DCF or whatever, Child Protective Services person. The malpractice wasn't on Beata, it was on Maya. Smith walked into Maya's room as an apparent agent of the hospital. So she's the one that saw this. As far as back to the negligent training, it is relevant. For the reasons we set forth and discussed at some length, the hospital is by law responsible for training and responsible for supervision. We also think for the reasons we set forth, it's not preserved. So if there are any other questions, I'll be glad to answer them, try to answer them. Otherwise, I guess it's break time.
Well, we're going to let Mr. Altenberg.
Oh, yes, sorry, didn't mean to preclude that. Sorry, thank you.
Mr. Altenberg, do you have a brief rebuttal on your new trial motion?
Testimony is about video. It's about the stuff that occurred in October. It's not about the photographs taken at the end. There wasn't any proof that Maya knew, that Ms. Kowalski knew anything at all about the photographs taken on January 6th. The record's clear on that. As far as Dr. Smith was involved in some things, she was a CTP person. She was doing investigations. We had to cooperate with her. Yeah, she was also interested in seeing what that video would do for her case. That didn't mean that she was treating as doing something that the Kowalskis wanted her to do because they thought she was an agent of the hospital, which is what apparent agency is about. Now, we can be responsible for what we did that day, but it's not because Dr. Smith was interested in doing it. That's a totally separate issue, but it ended up becoming this thing that inflamed the medical negligence claim that the CTP person was also interested in seeing the video on that. So that is, if it was anything, that would have gone to false imprisonment, but that is not something that should have ever gone to the jury on a theory of apparent agency for medical negligence committed by Dr. Sally Smith at any point in time after October 11th. So with that,
And before we run on break, let me just ask, and maybe you can think about this over break.
Okay, that's the end of that part of the argument. Now that's kind of all I wanted to really cover as far as the hearing goes. But when I was all of the financial things, all the miscalculations and stuff is not really the most thrilling testimony. But there was one thing that I thought was kind of funny at the 2:02 mark. Just as I was scrolling through. There's a way to tell when you've kind of started to lose your argument. And this is about the photographs. And maybe taking the photographs weren't a great idea, et cetera, et cetera. And then it builds into this crescendo where you can see that the defense is losing the argument because they start reeing at like full re capacity.
And then finally for the photographs that we took.
Oh, hey, we finally got the audio in both ears now. All right.
The photographs we took, because once we started back up at that point in time with Beata having Facebook time, the next day she has cuts on her body, and Dr. Elliott reported that he thought she was self-inflicted. And that the record shows, risk management knows that we're worried that she's now self-inflicting and mom's talking to her. And they wanted those pictures taken before and after she went.
But isn't the evidence also that the lesions are symptomatic of CRPS? And so don't I need to assume that those lesions are
what you have to assume for this case, for this part of it, and maybe he was negligent in that. If he comes back in here today, he's going to tell you those aren't CRPS lesions. That's what he believed. And that's what he told the jury he believed. And so maybe that's a negligent misdiagnosis, but was that something that was done at the level of intentional misconduct for punitive damages? So on all of these things, when you compare what we did to the tests, these numbers are multiple times higher than they should.
Should I also consider the evidence that was presented that the hospital did not believe Maya?
Mm-hmm.
I mean, how am I supposed to factor that, Mr. Altenberg?
I'm looking at
I like this. That's a great question by the judge.
a cut on the forehead that looks to me like a scratch, to be honest with you. I'm not a doctor, but I mean, it's
Clearly
not
not.
necessarily that they disbelieve this little girl. I mean, she's there.
It is absolutely the case they disbelieve. And stop calling her the fucking little girl. She's got a name, you son of a bitch. I can get really pissed off at that. They don't want to humanize her. They don't want to give her a name. They want to keep her as this nebulous thing, this little girl, and it's really starting to annoy the shit out of me. He will not call her by her name unless he accidentally does it at some point. This is all right, that annoys me. But yeah, they clearly disbelieved her because that was the whole thing behind this video setup. That was the whole thing behind taking the photographs of her nearly nude body, so you could catch her. And that was specifically what was stated. Not that they were making this surreptitious video to take care of her and watch out for her. No. They specifically said it was to try to catch her. Like she wants to be taken to the bathroom. They're not going to let her go to the bathroom. They're going to because they figure, if it comes to the crisis point where she's either going to shit herself or go to the bathroom on her own, she'll break down and go to the bathroom on her own. Well, guess what? She didn't. And time and again, they were trying to catch her by that video. So yeah, you cut the shit, lawyer.
They think in part for psychological reasons. It's not necessarily that she's doing things intentional in this situation. But I mean, you can factor that in. But if you do factor that in, that makes it $15 million or $10 million or $50 million for these things. That's an enormous amount of money for factors, for things for which there's no evidence that she got medical treatment before. We've suggested that she probably ought to have some psychological therapy that she's never had in this case. But whatever that is, these are not the kinds of things like, the tobacco companies get hit for $10 or $15 million, but they knowingly, intentionally hid from the fact that they were selling a product that was going to cause you an addiction that could lead to lung cancer. That's
different case, different facts.
They get high numbers because the facts are really pretty outstanding in those cases, and there's multiple people involved in that. So if you look at this.
Now this we're running up here to the full on moment when the judge asks him, because the idea with the standards of these punitive damages is you can't give punitive damages at such a level that it bankrupts someone. They're supposed to punish but not totally destroy someone. And that's just, they made too much money. And the judge starts to question, well, was it really too much money? Didn't they really have assets to do this? And then it kind of goes off the rails for the defense a little bit.
The way it is, I submit to you that those numbers are far out of range for anything that's reasonable. Now, can we not file bankruptcy? Well, probably not. But the front end test is, does this conduct warrant how much money as a deterrent? And these numbers are sky high on that. And
I'm just because we're in a remittitur situation.
And you can do a remittitur on this as well. Yes, you can.
And a remittitur is what we were talking about earlier, where it's like, okay, forget what the jury did. The judge is just going to step in and go, all right, this monetary award is off the table. I am going to set what I think is the correct amount of damages. That's what they're wanting the judge to do. If all else fails, if all their other arguments fail and they don't get a retrial, they want the judge to come in and go, all right, we're setting aside the $261 million, and here's the amounts I think are correct. That's what the remittitur is.
And
it's just your argument seems to be more of a new trial type argument as opposed to a remittitur argument on.
I'm gonna slow this down to normal speed so you can get the full impact of
this punitive damage, because I don't hear you saying that.
Well, the only reason
I look at the judge. The judge is smiling. That's a little bit of a telegraph there too. That he's not buying what you're selling. The judge when he's going full you can see the judge actually cover his mouth to try to hide a smile. I think, at least that's how I'm interpreting what he's doing.
The biggest reason I think there's a new trial, and it's this last part, is when we get to the claim about whether there was specific intent to harm her. They are correct, by the way, and I was mistaken at the time of trial, but I can be perhaps forgiven for the fact that I found out they wanted this in the morning, had to leave the courthouse, go back to my hotel room and try to research this and come back that day. But the standard jury instructions on this, if I can find this in the form, this is bracketed language. So it's optional bracketed language. And it says in comment 6, Instruction 503.1C2C should be used only after the court has determined the evidence includes some additional circumstances that may affect the amount of the punitive damages. Well, the way for you to, because this, if you read the text of the statute, is not a measurement of damage. It's,
Just so I'm clear, are we talking about the adding the question in phase 2?
yes.
That actually was the proper way of doing it?
Well, I will tell you that the standard jury instruction puts that option in there. I'll tell you that the standard jury instruction is dead wrong, because it's not something that is used just to measure damages. It's something that lifts the cap. The jury never knows about the cap. This is something that takes you from having an award of up to, I'm not going to have the number in front of me, but it dramatically increases the ability to do it. But it also puts into the mind of the jury, well, was there a specific intent to do this, which changes the dollar amounts in this thing.
Well, but let's,
You can't change that cap unless you have clear and convincing evidence of something.
I mean, isn't this really an academic discussion?
No, it's not, because
Why not?
because they were supposed to give me their jury instructions by mid-August. They didn't.
Free.
They never gave me that
Free.
punitive damages instruction until the morning it was going to be used in the afternoon. And that was my first notice that anybody had any thought that this case involved specific intent crimes by my doctors. And I submit to you that there is no evidence that anyone in the emergency room or the pediatric intensive care unit had a specific intent to harm Maya Kowalski when they kept her there under their care. There was no specific intent to harm her in the other two areas as well.
But isn't the cap not exceeded in this particular case anyway? So isn't this really?
It's exceeded because all the other damages are excessive. And because you put this thing twice on the verdict form for them to focus on, well, yeah, we should give them higher punitive damages because there's a specific intent. I submit to you that there's no evidence of that. And I never got to make any predicate motions to have that stricken from a complaint or stricken from jury instructions. I never had an opportunity while there were witnesses there from management, because this is a management test of specific intent, not that to be able to put on evidence about this.
Well, but assume I messed up. That would have been a mess up in the punitive damages portion.
Yep.
And Mr. Shapiro's argument seemed to be very persuasive to the jury.
Right.
The fact that the jury awarded 10, 15, and 25 million only when there was evidence of what, $500 million of securities and free cash. So I'm just saying Mr. Shapiro's argument seemed very persuasive.
I like that statement by the judge. It was like, this 5, 10, 15, $25 million, it was too much. Why was it excessive? Well, because it was based on something else that was excessive. So this is by definition excessive, blah. And he's saying, well, because you can't bankrupt them, but you can make it hurt. And he's saying, well, it could have been much higher because they had like $500 million. They had $500 million worth of assets and cash that could be used to satisfy a judgment. But Shapiro argued very effectively that would be excessive. So that's why the jury came and gave the verdict for the 5, 10, 25 million instead of a much higher punitive damage. So you should be thanking Shapiro there that he argued so effectively that you didn't get a $500 million judgment against you. I liked the way the judge summarized that there. Well, that is kind of all I wanted to talk about for the hearing itself. And then following the hearing a few days ago, the judge released his order regarding this. Before we get there, and that's when we'll wrap it up. We want to Karen Ricci, member for 3 months, is Merry Christmas. Merry Christmas to you too, Karen Ricci. Thank you for being a supporter for 3 months. And Rainman YYC with a Canadian 5. Will there be anything left for the appeal court to do after this? Well, I mean, we haven't got to the appeals yet. This is just the post-verdict motions. Once all this gets settled, then it will go to the appellate court. And what they'll argue in the appellate court is pretty much exactly what they're arguing here. Oh, the judge should have given a new trial. The judge should have done this, so let's do it. They're going to make the same arguments to the appellate court that they're making here if they don't win. And Julio, $5. Did I hear retrial? Yeah, they were asking for a retrial. Don't yell at the judge. That clearly indicates that you've gone off the rails and you've lost your argument. When you have to increase the volume to make it more persuasive, you've lost. And Matthew agrees with it again. 2 more euros. Anderson asked for 600 million. Do I give him a redo? Yeah. Yeah, go ahead. Give him a retrial and ask for more. But now we don't want to do a retrial. We definitely don't want a retrial. Oof. All right. Well, we'll quickly read through this order, which will explain a little bit more the judge's thinking, because the judge has said that they will bring juror number 1 in, and the judge will question him on January 3rd, which I don't have a problem with. I'm in the I don't have a problem. How are we doing on our poll anyway? 54% say you're angry that the juror number 1 is being interviewed. 18, we're at exactly where we were before. 18% say it's understandable. I'm in that 18%. It's understandable. 21% is make it make sense to me, and 8% say you don't care one way or the other. And I'll explain why I think it's okay as we go through this. But generally speaking, the reason I think it's okay is the judge wants to be very, very careful to show that he seriously considered all of the arguments that were being made, so that this doesn't become an appellate issue. He wants to be able to say, look, we talked about it. I brought juror number 1 in. I asked him the questions, and these are the answers he gave. And I'm just assuming that if the motion for a retrial is denied, this will be the reason why. I brought him in here. He said he didn't do anything improper. There's been no concrete evidence that he did anything improper, so therefore I'm doing this, rather than just throwing it out now and giving them another piece to go to the appeals court with and say, he didn't do this. He should have done this. He didn't do it properly. Meh. So I think this is actually a very good thing for the judge to do. I think it's very exceptional. You do not bring jurors in lightly for any questioning. So it's an exceptional thing, but I think it's called for in this case, given the publicity of the case, given all of the eyes that are on it. I think it's important to bring him in and ask juror number 1, did you have any improper communications? Did you talk to your wife about this? Did you do that? Hell, you can do it in half a dozen questions. You can do it in half a dozen questions and then say, all right, you're out of here, and no, your motion's denied. Give them the double fingers. Again, I think it's appropriate. I think it's understandable, and I think it's acceptable. And I think the judge is doing a CYA here. He's covering his ass so that it can't be raised on an appellate issue that he didn't do this. He didn't grant it when he should have. He said, I did it, and I got their answer, and here's how I rule. That's kind of the short logic and the short rationale for why I think it's perfectly acceptable and appropriate, and not all that unsurprising. Not all that surprising. They did that. And Mathis again says, juror interview, like low punitives equals safe verdict. Get it in there, and then they can't bitch and complain and argue to the appellate court that you didn't bring him in. While Judge Carroll may be very careful in his interview, this sets a precedence that allows other judges in the future trials to do this. It's still a very, very unusual move. I don't think, there are maybe moving forward as we continue to embrace social media. I think before you see more jurors brought in, I think you might be seeing some more. I don't know how you could put a restriction on someone who's not a juror to post things. I don't know, but I don't think it's really going to do this, because the facts surrounding this motion are actually quite exceptional. They might become more common in the future. We'll have to see. And maybe it will dissuade people's wives or husbands from posting things online if they don't want their husband or wife juror to be hauled into court to answer questions to the judge. I don't know what this is, I mean, honestly, the first time something like this has probably ever happened. But let's look at the order and see how much how much more light gets shed on reasons and rationale for doing things. Where did I put it? All right, here it is. Let me share the screen. Window, boom, bang. All right. Oop, there we go. Move me and the doggos over to here. That's no, can we? Let's see how much we can embiggen this. All right, we're gonna have to do either under here. Yeah, there we go. That's what we'll have to do. And then we'll have to bring this back down. All right, there we go. Oh, before we get going, Duncan, Idaho has brought in a $20 super chat. Thank you so much for the generosity, sir. I think it's understandable because there's no reason to assume that arguments from emotion from a powerful and wealthy defendant in appeals court don't succeed. So you have to absolutely nail it down and address everything. Again, that's why I think it's appropriate to that's just one more I to dot, one more T to cross to say, I did my due diligence as a judge. I did what I had to do. I listened to them. I'm not convinced by it. That's my thoughts. But here is the order permitting limited. And again, as we go through this, I want you to see that he's basically siding with the plaintiff's arguments regarding this, because the defense, they wanted their own lawyers to be able to question the witness. They wanted to be able to ask about pretty much everything they could think of, and they wanted they wanted to rummage around in their electronic devices. And the plaintiffs asked for the judge to do the questioning of the juror and limiting the scope. The order permitting limited juror interview. The jury in this case rendered its verdict against defendant Johns Hopkins All Children's Hospital in both the compensatory and punitive damage phases. Defendant filed its motion seeking a new trial based on alleged juror misconduct of juror number 1, requesting a juror interview together with expansive discovery. Defendant has supplemented that motion 3 times in writing. Plaintiffs responded in opposition. Defendant's motion weaves together several alleged violations of the court's instructions or misstatements on the juror questionnaire. During argument, defendant contends that while each in isolation may not rise to the level of requiring a juror interview, the cumulative nature of them, according to the defendant, shows a predisposition on the part of juror number 1 to violate the court's orders, which has a material effect on the verdict. Again, this isn't what the court is saying. This is what the defendant is arguing. The foundation of much of defendant's motion is defendant's continued insistence that juror number 1's questions of the witnesses during the trial showed bias against defendant. This is where the court immediately starts to put his foot down. The court previously decided that issue adverse to defendant. Like they're arguing this again, that he was somehow predisposed, when I, the judge, have already previously decided that he wasn't acting in a prejudicial or biased manner. Plaintiff contends that, so there he's kind of digging a little bit in, going, this has already been decided once. Plaintiffs contend that no juror interview should be permitted. Fair enough. But then he said, but if, this is how it should be done. In summary, plaintiffs contend that defendant did not meet the standard for a juror interview, and the defendant is too late with their complaints. Plaintiffs suggest that defendant's basis for the juror interview is based on rampant speculation. Plaintiffs also present contrary evidence disputing the theme of defendant's motion. Well, Florida Rule of Civil Procedure 1.431H governs the request for juror interviews in a civil case. The rule provides a party who believes that grounds for legal challenge to a verdict exist may move for an order permitting an interview of a juror or jurors to determine whether the verdict is subject to the challenge. The motion must be served within 15 days after rendition of the verdict, unless good cause is shown for the failure to make the motion within that time. The motion must state the name and address of each juror to be interviewed and the grounds for challenge that the party believes may exist. After notice and hearing, the trial judge must enter an order denying the motion or permitting the interview. If the interview is permitted, the court may prescribe the place, manner, condition, and scope of the interview. Although trial courts should be hesitant to grant motions for post-trial juror interviews, such interviews are proper when there are reasonable grounds to believe misconduct has occurred. The second district has summarized the general standard applicable to a motion for a new trial based on juror misconduct. So there has to be at least a reasonable grounds to believe misconduct has occurred. Reasonable grounds to believe conduct is miscarriage. And here's how we interpret that. An inquiry is not permitted unless the moving party has made sworn factual allegations that, if true, would require a trial to order a new trial using the standard adopted in State v. Hamilton and Baptist Hospital of Miami. And under the Hamilton standard, the moving party must first establish actual juror misconduct. The movement is entitled to a new trial unless the opposing party can demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. Okay, that's setting out the standard. It's a pretty tough standard to meet. Nationwide Mutual Fire Insurance Co. v. Trucker. Where's the trucker? Juror interviews are appropriate only to investigate matters extrinsic to the verdict. So outside of the verdict, you can't get into what's going on during jury deliberations and how the verdict itself was reached. Only things outside the verdict itself. Inquiry into the individual thought processes, calculations, or judgments of the jurors is prohibited. So in order to constitute juror misconduct and therefore a matter extrinsic to the verdict, sufficient to set aside the verdict, or for a post-trial jury inquiry, Florida and other courts have consistently held that some objective act must have been committed by or in the presence of the jury or a juror which has compromised the integrity of the fact-finding process. A motion for juror interview need not conclusively establish juror misconduct. So when you're making the motion to interview a jury, you don't have to prove conclusively that there was jury misconduct. The moving party must only establish a basis for the inquiry. So, if the basis is essentially if what the defense is alleging is true, if he actually did all of these improper things, they would be entitled to a new trial. That is essentially the basis. That's it. The basis for inquiry, it is appropriate to grant a jury interview, allowing the moving party an opportunity to prove, if possible, an entitlement to relief based on the allegations. So I think where the court's going with this is saying, okay, if we accept as true every single horrible thing that the defendant has stated that juror number one did, if we assume that is true, they would be entitled to a new trial. So let's bring the jury in. Let's bring the juror in. Let's ask him if he actually did these things he's accused of. If he says no, then the state has failed to prove that because that's what it says here. It's appropriate to grant a jury, allowing the moving party an opportunity to prove. So they're going to give them the interview, and during that interview, they're going to allow them to try to prove that there's a basis for overturning the verdict. And I think it's going to go not quite the way they think. As the court noted before trial, this is a case of intense public interest. It has generated significant media attention over the span of years, locally, nationally, and internationally. The media coverage has consisted of newspaper and television accounts, and very recently a national magazine article printed online, a streaming movie on Netflix released on June 19th, 2023, podcasts, a potential book, and other comprehensive print, television, and online coverage. News accounts detail that as of July 3rd, 2023, the movie has been streamed more than 10 million times internationally, and it reached as high as number 2 on Netflix's U.S. movies category. Again, he's saying this is what we were talking about a minute ago, there's a whole bunch of eyes on this trial. So attending the trial daily were members of the traditional media, as well as members of various internet communities who reported on the trial to viewers of various platforms. There were 2 media cameras in the courtroom each day, beginning with opening statements, and this feed was broadcast in real time on the internet and picked up by various internet shows, either live or in recaps. Additionally, the court operated a Zoom webinar with 4 different camera angles, and members of the public were allowed to access but not rebroadcast the court's Zoom webinar feed. Parenthetically, members of the media attended both the individual questioning and the group questioning of prospective jurors, but the media chose not to broadcast jury selection. The court also had an overflow courtroom so additional members of the public could attend jury selection. Here we're still laying the foundation for the ruling here. The court notes that the daily broadcast of the courtroom proceedings to give context to the motion and response. Plaintiffs allege that some portions of defendant's arguments are based on investigations conducted at defendant's request by various internet communities, Reddit, favorable to the defendant. Defendant has not, okay, this is a good one. Defendant has not denied that belief, but has not expressly agreed to it either. That's what we saw when you say, okay, who told you this? Oh, somebody. Well, who is this somebody? Oh, people. Shapiro would not admit that he was scrounging around on Reddit for this. And this is kind of this again sort of telegraphs that the judge, at least it telegraphs to me that the judge is not sympathetic to the defense's case at all. He's saying that this to me just says he knows what they're doing. Defendant has not denied that belief, but has not expressly agreed to it either. They're playing coy, and the judge knows it. The court will later address a concern about either side deputizing an online community to take actions that the party cannot do itself. Yeah, you can't do something, and your agent can't do something. So I can't, if I'm not permitted to do something, I can't hire a private investigator or a personal researcher or send out a paralegal to do something. I can't do that. So if whoever I'm appointing is an agent to go out and do this, they're bound by the same rules as me. So if I can't do it, the people I appoint can't do it. Much of the defendant's initial motion focuses on the alleged actions of juror number 1's spouse. Again, I think it's kind of telling that the judge is mentioning at least impliedly that there's not a lot about what juror number 1 did in the motion. It's all about his spouse. Defendant's motion states that juror number 1's spouse attended the trial on October 30, 2023. Defendant points to screen captures from the media feed that depict a woman believed to be juror number 1's spouse talking with another person in the gallery whom defendant identifies as Jules, who apparently has her own online show on TikTok and who would call it into other online programs on YouTube. Defendant contends that Jules was pro-plaintiff, going so far as to accuse Jules of being plaintiff's agent. Defendant's suggestion that Jules was plaintiff's agent is mostly conjecture. So right there, the judge is saying, all right, telegraphing that I think this is complete bullshit, but he can't say that in that particular way. So he's admitting, the judge is saying, look, it's mostly conjecture. Attorney Greg Anderson issued an affidavit rejecting that Jules was plaintiff's agent. So the judge, I don't see the judge coming anywhere close to ruling on that issue. He's basically rejecting it here. So kind of where he was up here saying that the defendant has not denied that belief, but has not expressly agreed to it either. This to me seems to be the judge saying, I'm not ruling on this right now, but I'm kind of ruling on this right now. It's a non-starter for the judge as far as I'm concerned. That's how I'm reading this. Defendant also points to social media posts during the trial made by an online account that has been attributed to juror number 1's spouse. Defendant argues that juror number 1's spouse heavily was pro-plaintiffs. To suggest juror misconduct, defendant baldly asserts, not boldly, baldly asserts, without any support, without any evidence, without any indication that what he's saying is true, just bald face, just on its surface, without foundation. Defendant baldly asserts it strains credulity to believe that juror number 1 and his spouse were not discussing the case in violation of this court's instructions. Again, that use of the word baldly is very telling, at least to me, of where he's going with this. Defendant seeks to piece together occurrences in the trial to suggest there must have been discussions between them. In reviewing the posts attributed to juror number 1's spouse, objectively, though, In reviewing the posts attributed to juror number one spouse objectively, though, the court observes that they are not necessarily indicative of improper communications or other misconduct. Again, setting it out there that this statement that, oh, they had to have been discussing it because they were married is without foundation whatsoever. Regardless, there were no court instructions that restrained any juror's family member from watching the trial or publicly expressing their view about the case. In this context, the court currently does not believe it necessary to interview juror number one spouse. Boom, that's out the door. We're not bringing her in because she had nothing to do with it. She was under no restrictions. She's completely free to do whatever the hell she wants. So the judge has already booted that out. There's another L for the defense. There were, however, constant instructions to the jury not to discuss this case with anyone, not to receive any information about the case outside the courtroom, and not to investigate any aspect of the case. There were also instructions not to review any media coverage of the case, and the jurors were instructed to report anyone attempting to approach the jurors. Now, while defendant's assumption, again, he puts that in italics for a reason. It's only an assumption by the defense. It's only an assumption. It's so much of an assumption that the judge put assumption in italics. While defendant's assumption that juror number one and his spouse spoke about the case certainly is not evidence. Yeah, their assumption is not evidence. The court concludes under these very unique facts that defendant has made a sufficient showing for an interview of juror number one. Okay, so he's saying the assumption is not evidence, but if you look at all the allegations and all this stuff, we think there's a limited juror interview is appropriate. He's not saying that he's going to allow a huge interrogation. He's just saying, like, considering all the allegations that have been made, if we assume they're correct, there might be grounds for a new trial. So we think it's just at least appropriate to bring juror number one in and ask him a few limited questions about what he did. So where an interview is permitted, so there we have his wife is not going to be interviewed, only juror number one. Now, what's the scope of these going to be? Where an interview is permitted, Rule 1.31H provides that the court may prescribe the place, manner, condition, and scope of the interview. There is some authority that would permit the court to allow the jury interview to occur in private outside the presence of the public and media. Counsel has a right to be present during the juror's interview as well as to retain a court reporter to report the proceedings. The court, instead of counsel, may conduct the interview. Now, case law prohibits any inquiry into any matter that inheres in the verdict itself. Putting this more directly, juror number one's thought processes about the evidence and juror number one's discussions with the other jurors during their deliberations are not proper subjects of a juror interview and will not be allowed. So again, this is going in support of the plaintiffs. Because the defense, they want to talk about, what did you talk about to the jurors? Did you talk to the other jurors about this? Did you force the questions? Did you force your opinion on the other jurors? How was it, what was their makeup? They want to ask all these questions apparently. And the judge is saying that's not going to be allowed. All right, not subject to the interview, not allowed juror. Okay. Juror number one's position, if any, with respect to the case for or against any party is beside the point. So juror number one's position, whether he's biased or not biased, that's not important. It's whether he did this. The issue is whether juror number one engaged in the alleged misconduct. That's the crux right there. Not who he supported, not was he pro plaintiff, pro defense. That's not important. Just did he follow my instructions? That's all we're going to look at. The interview, though, will not include each topic contained in the motion. So he's not giving credence. He's not going to ask about everything that the defense wants to ask. The court will not address with juror number one the matter involved in the second supplement. That is the 20-year-old allegation. Was that no? The second supplement was the Nazi lightning bolt. So they're not going to get into the Nazi stuff. So that's just right off that tells you the judge was kind of upset about that. He's not even going to entertain that. In the second supplement, defendant points to juror's handwriting in an October 12th, 2023 juror question. Defendant posits an excerpt from the website of the Simon Wiesenthal Center documenting the appearance of a uniform badge of the Nazi Germany Schutzstaffel or SS is attached as Exhibit B. It will be noted that in Exhibit A, juror number 1 has printed letters S throughout the note normally with a curve in the spine, except when he printed his S with sharp angles when printing Dr. Sally Smith's name. Both the second and third times that juror number 1 prints Dr. Sally Smith's names, the letter S is shaped in a manner identical to the symbol of the Nazi SS exhibited in Exhibit B. Printing the first letter of Dr. Smith's initial and last name in this manner makes it clear that juror number 1's bias and prejudice against Dr. Smith, and thus equating Dr. Smith with a notorious Nazi organization. In addition, juror number 1 on October 10, 2023, printed Exhibit C, in which he effectively prejudged the relationship between defendant and Dr. Smith, equating one with the other. The issue is waived or untimely or both for at least 2 separate independent reasons. So he's saying we don't even have to look at this because it was just too late. They brought it up way too late. First, defendant saw juror number 1. This is the first thing the court went in on him. We were like 5 minutes into it, and the court went straight at Shapiro with this one. Defendant saw juror number 1's handwriting on that juror question when it was asked, and in fact had a copy of it during the trial. The court, after reviewing each juror question, handed the attorneys the actual question written by each juror, meaning each attorney could visualize the handwriting. Further, during the trial, defendant asked for, and the court arranged for defendant to obtain all juror questions, including juror number 1's question during trial. Defendant did not raise its motion to disqualify juror number 1, or did not raise in its motion to disqualify juror number 1 made during the trial, or at any time before the second supplement, any suggestion that juror number 1 equated Dr. Smith to being a Nazi. So yeah, they had it, they saw it, they looked at it, it was in their possession. They didn't bother raising this until well after the trial when they submitted the second supplement. The second reason, defendant filed the second supplement more than 15 days. They have to make the assertion within 15 days. So the defendant filed the second supplement more than 15 days after the jury verdict. Rule 1.431H required defendant to include its grounds in its motion that had to be served within 15 days after the rendition of the verdict. This 15-day rule implements the strong public policy against allowing litigants either to harass jurors or to upset a verdict by attempting to ascertain some improper motive underlying. So you have if you're going to harass the jurors, you got to do it within 15 days. That the second supplement issue is either waived or untimely or both means the court does not need at this time to evaluate whether defendant had a good faith basis when counsel signed and filed the second supplement. To be clear, the court is not reaching that issue. The court ain't even going to touch that issue. That's what they're saying. We're not going to touch it. We don't have to. It was filed late. We're not even going to look at it. The court does, although, caution all counsel for deputizing an internet community. Here we get into the internet community. It'd be interesting to see what he says. The court does, though, caution all counsel for deputizing an internet community to do indirectly what an attorney is expressly prohibited to do directly. Florida Rule of Professional Conduct 4-3.5D4, which previously had been found to be constitutional, prohibits attorneys from having direct or indirect post-trial communication with jurors in a civil case, except as outlined in Rule 1.431H. The court also will not address with juror number 1 the matter involved in the third supplement. That was the 2016 allegation about his son had apparently threatened to kill them or something like that. He's not going to address that. Why? In that supplement, defendant claims juror number 1 falsely answered during voir dire that he had not previously been a victim of a crime. Defendant only recently has provided documents indicating juror number 1 sought and received an injunction for protection against repeat violence in Charlotte County, Florida in 2016. Defendant asserts it learned this information after entry of the verdict, but this third supplement raising this claim was filed several weeks after the 15-day deadline and does not attempt to show good cause for this delay. So yeah, even though it's filed more than 15 days after, if you have a good reason for it, you can still submit it. The court saying this was weeks after the 15-day deadline expired, and they didn't make any attempt to show why this delay happened. Accordingly, the claim is untimely. So they're not looking at the 2016 incident. They're not going to talk about the nausea SS things because they brought those up too late. Too late, you lose. Good day. The court believes an interview here. Oh, see, this is very, very short. The court believes an interview of juror number 1 is sufficient to address the issues raised by defendant, and there is no need for invasive discovery, such as forensic searches of phones or computers. So the court again sides with the plaintiff and says we're not going to let the defense root around through their computers, their phones, and other electronic stuff to search and go on a fishing expedition for evidence. The only topics on which the court will permit an interview of juror number 1 are, number 1, whether juror number 1 received or shared information about the subject matter of the trial through outside sources, including his spouse. 2, whether juror number 1 conducted an investigation about the subject matter of the trial, including looking up websites. Juror number 1's knowledge of Deborah Salisbury, if any, at the time juror number 1 completed the supplemental questionnaire. And 4, whether juror number 1 had an undisclosed opinion concerning DCF or any prior entity during jury selection, and whether and to what extent juror number 1 and DCF or any prior entity were involved in Broward County Circuit case number 2, blah, 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 whatever. So that's it. That's all they're going to be asking the court. That's all the court is going to be asking. The lawyers aren't going to get a crack at it. The court will be asking those questions. In this case, the court will decline to interview juror number 1 in a place other than open court. Public confidence in the process is important, and the court will therefore conduct the interview in open court. The court will be the person to ask the questions of juror number 1. After the court has completed its questions, the court will permit the parties to suggest to the court additional concepts that the court may ask juror number 1. It is therefore ordered, 1, the court will allow a limited interview only on the topics identified in this order and under the conditions referenced in this order. 2, defendant is ordered immediately to send juror number 1 a subpoena via process server or sheriff's directing juror number 1 to attend the juror interview, which is currently set for 3 p.m. on Wednesday, January 3rd, 2024 in courtroom 2A in the Silvertooth Judicial Center. Defendant shall also include in the service package a copy of this order, a copy of the notice of the hearing, a copy of defendant's original motion for juror interview, and a copy of the first supplement to the motion. When defendant files the return of service and copy of the subpoena, the defendant shall file a notice of confidential information identifying the clerk to redact the address of juror number 1. See, you shouldn't have to be told to redact the address of juror number 1 anywhere in the papers filed. You should have done that anyway. But because they fucked up the first time, the court has to go out of its way to tell them not to fuck up a second time. The defendant shall refer to this order directing the clerk to keep juror number 1's address exempt from public disclosure. Done and ordered at Sarasota County, Florida on December 20th, 2023. Hunter W. Carroll, Circuit Judge. And that is the end of that. Let me do this. Whew. Right, we got through that. So, as I said, I'm in the camp that I think it's okay to interview the juror on those specific 4 issues, only for the judge to do the questioning, for it to be limited, and in open court. I think because there has been so much media attention to this, if you do everything out in public and then this one important thing that will shift the balance of whether or not there's going to be a retrial, if you put that behind closed doors, there's always going to be some skepticism by one party or the other that some shenanigans happened. So I think if you do the interview, you have to do it in open court. It sucks, and it's probably gonna have repercussions with people not wanting to be involved very much in the jury process anymore, if they're aware of this. But I think it has to be done, as he said, for public confidence. You don't want to take the most important thing and put it behind a closed door where no one can see what happened. Spurgs on both sides of the fence are raising these issues. Let's let everybody see it. So I'm comfortable with having this because I see it as a big win for the defense. I hope I'm right. I hope the judge just goes down through those 4 questions and then goes, all right, this is stupid. Everything he asked for is denied. And I'm not saying the judge is biased at this point or prejudiced towards one side or the other, but I think he knows he has his questions and he wants his questions answered. Whether it supports what he's thinking or not is up to him. But okay, let's bring him in. All these allegations have been made. And if these allegations are true, if he did everything that the defense has alleged that he's done, if he's done all of that, clearly there needs to be a new trial. Let's bring him in. Let's ask him if he did it. He's going to say no. I assume he's going to say no. And then the defense has better come up with some evidence as to why he actually did it. Otherwise, it's going to get tossed. That's, hey, Danny, what's up? Danny on direct in the house. I always come vote and then listen in, lol. You're lurking. Danny on direct lurking. She's a lurker. Thank you. Thank you so much. Good to see you here, Danny. Good morning to you, by the way. Good morning. Good morning to Utah. And as we begin to wrap this up, let's look at the final super chats that have come in from you generous supporters. You guys are so awesome, and I deeply appreciate everything you do to support the channel. Never, ever taken for granted. Let's see. Here we are. Duncan, Idaho with the $5. They also lived in the same house, Jeff. You forgot about that part. Oh, I didn't forget about it. The judge just didn't raise it. Yeah, those clearly the defense. I mean, I'm so flustered. The defense frustrates me so much. Well, there had to have been jury misconduct because the person posting about this was married to the jury. They were living together. So they had to have talked about it. Just you make that assumption. It's incredible to think that they wouldn't talk about the case, and they were probably even sleeping together. Ugh. Defense sickens me. Kevin Collins says the problem I have is not the interview itself, but now a juror needs to hire a lawyer for himself, being pulled into the system he already served. That's true. That's a thing. That's what I hope. I hope he's got a lawyer, which I'm sure he does. And it is unfortunate that it has to happen. But I'll play devil's advocate on this one and say that if his wife hadn't been doing these things, and it is completely within her rights to do what she did. But I'm just saying, you can look at it from the other side and go, well, even though she could do something, doesn't mean she should do something or has to do something. If she hadn't have done this wouldn't be an issue, and he wouldn't have to get a lawyer. I'm not saying that I agree with that view. That is just purely me taking the devil's advocate position. Say there is another argument on the other side saying he kind of brought this on himself. But I'm on your side with this one, Kevin. I'm just playing devil's advocate. Don't hate on me. Don't hate me, bro. Rain Man YYC, damn it. Now I have to update my handwriting. Lightning bolts for S, hammer and sickle for G. This is going to take me a lot of work. Well, yeah, but you don't have to do that. Just saying, you don't have to do that. All right, folks, we went an hour longer than we should have. What I'm going to do now is send you on over to Nicholas Starro. Nicholas Starro is he's looking at a case that we're going to be looking at tomorrow. You may recall there was the the case of Aguilar Mendez, the South American migrant worker who was tased by a police officer and had the unfortunate situation of being near the police officer when he dropped dead several minutes after he was arrested, and they charged him with murder. So yeah, we went back, go back about 3 weeks ago. We covered this. We read some news stories. We played partial body cam footage of this. Guy doesn't speak English at all. He barely speaks Spanish because he's from some tiny little tribe in South America that speaks their own language. And the cops approached him, asked him some questions, took him to the ground, tased him, and struggled for about 6 minutes to get him under arrest, which was mainly him screaming for his family and whatnot. Then the arresting officer drops dead a few minutes later, and they charged him with murder. It was later reduced to aggravated manslaughter. Well, Nicholas is going over it right now, and we're going to go over it tomorrow. We're going to show the full body. We have the full body cam video, and it is horrific and difficult to watch. There's more than one tasing going on. In my view, they essentially tortured this kid with a taser. And then there was also a hearing on his mental competency, where you get into a lot of very interesting cultural things about his language and how his native language is structured around metaphors and things. It seems kind of literally like the Star Trek Darmok and Jalad Tanagra kind of a thing. And you'll see things like they had one of the expert witnesses was saying that he can't differentiate between being guilty, pleading guilty, and being found guilty. Like in his head, they're all the same thing. There's some very interesting linguistic, cultural, as well as some mental capacity questions that are going to be raised during this competency hearing. So we're going to watch the competency hearing and the full body cam video and an update on what killed the police officer. So stay tuned for me tomorrow. But right now, Nick Starro is covering that himself. So I'm going to put everyone there to kind of give you a little bit of a preview as to what's coming up tomorrow on my channel. So that's something you want to stay tuned for tomorrow. Let me flip through this. Hit the live. Go to the studio. Customization. Redirect to Nick Starro. Nick Starro. There you go. All right. We are set. So again, before we, in the last few seconds here, anybody that hasn't hit that like button, do me that favor and hit that like button. We have 648 of you here and 672 likes. Woohoo, we got over the 600 likes. That's pretty awesome. Thank you so much. And 25 new members from all of the gifted memberships and the self-purchase memberships. We picked up about 12 new subscribers as well. If you haven't subscribed, please do me the honor of subscribing to the channel. Stick with us. We cover all trial things that we possibly can, all legal news we possibly can, and we try to do it with a little bit of snark, a little bit of humor mixed in with this to kind of take the edge off the seriousness of it all. So let's look at this, and thank you, mods, for being here and doing everything. That's so awesome of you to do this, as always. Can't do this without you, mods. And everybody, go back and watch our very moddy Christmas we did last week. Meet some of the mods. Great people. And chat, thank you as always. The Vice Squad chat is the greatest chat on the internet. Hands down, no question. Vice Squad, you guys rule. Everyone that's here is a member of the Vice Squad. And thank you so much for all of your generosity with the super chats, the membership gifts, and the purchases. Thank you so much. Let's go on over to Nick, and I will see you tomorrow at the same usual time. Until then, whatever you do and whoever you do it with, just make sure you're enjoying your legal vices. Lorax out.